We're meeting in Jackson, Tennessee, and we're videoing this, right, Brooke? This will be on YouTube soon, okay? So if you'd like to watch it again, you feel free to. Before we get started, I'd like, on behalf of the commission, to thank the Central West Tennessee Association of Realtors for the hospitality they showed this commission last night. We appreciate it, and I'm sure, speaking for everybody here, we had a great time. So again, thanks very much. All right, with that said, and I apologize for the late start. We had to have an executive session with the Attorney General's office on an item we handled previously. We're not necessarily used to having executive sessions with the Attorney General's office, so it took us just a little longer than perhaps it should. But with that said, we'll ask our Executive Director, Malcolm Young, to read into the record a public statement.
Good morning, and thank you for your hospitality in Jackson, Tennessee. And I need to read the public disclaimer. I'm Malcolm Young. The meeting date and time and location have been noticed on the TN Real Estate Commission's website, included as a part of this year's meeting calendar since July 1st, 2015. Additionally, the agenda for this month's meeting has been posted on the TN Real Estate Commission's website since Friday, April the 29th, 2016. Also, this meeting has been noticed on the tn.gov website since Friday, April 29th, 2016. Thank you, Mr. Chairman.
Thank you, Mr. Young. At this time, would you also call the roll?
Yes, sir. Roll call of the commissioners today. John Grease.
Here.
Janet DeChera.
Here.
Gary Bloom.
Here.
Diane Hills.
Here.
Austin McMullen. Marcia Franks.
Here.
Bobby Wood.
Here.
Fontaine Taylor.
Here.
Johnny Horn.
Here.
Mr. Chairman, you have a quorum.
All right, 8 out of 9 members present, so we're good to go today. Just a couple of items. This meeting could be as long as 2 days long. However, we don't think that's going to happen, all right? But I will tell you that we'll break around 11:30 for lunch. Now, it might be plus or minus a few minutes either side of that, so don't get antsy at 11:30 and start getting up and moving around. We'll come back at 1 o'clock, and we expect to finish our agenda this afternoon. So if you're making plans for tomorrow, so are we. Okay, we don't expect to be here. All right, if you will also make sure your phones are turned off, your tablets are turned off, whatever other electronic devices you have, we'd appreciate that as well. There'll be breaks, and you can do business during the breaks. At this time, we have one public member of the Real Estate Commission up here today. It's Reverend Johnny Horn down here at the end. The balance of us are licensees and active in the business. We're going to ask Reverend Horn, who is also a Vietnam veteran, to give us the invocation and lead us in the pledge. So after the invocation, if you'll stand, Johnny Horn will lead us in the pledge.
Let's pray. Father God, we do thank you for an opportunity to assemble with the idea of doing the king's business, doing the people's business. And we pray, Father, that we would supervise in such a way that no person might feel that they were slighted or used by a system to do some things that is not right. Lord, we thank you for what you're going to do. We ask you to use our minds and our hearts. In Jesus' name we pray. Amen.
Amen.
Would you stand, please?
Please stand.
Let's pledge.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, before we get started, one more piece of information. Anybody in here during the breaks should feel comfortable approaching any of us about any questions you might have. Just for the record, at the end to my right is Jenica Smith, who's a paralegal with Department of Commerce and Insurance. You want to hear us? I'm good with either one of them. Valerie Kirby is an attorney who represents the Tennessee Real Estate Commission, assigned to the Department of Commerce and Insurance. And Brooke Wagner here in front of us is administrative assistant to Malcolm and probably knows more than anybody else. So you guys feel comfortable to approach us, ask us questions. We don't have a public forum section, so ask us individually when you get a chance. All right, with that said, we have to approve today's agenda. Is there a motion?
So moved. Second.
I have a motion made by Commissioner Frank, seconded by Commissioner DeChara, that the agenda that was submitted previously be approved. Is there discussion? Are there amendments? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next up is to approve the minutes of our last meeting.
Motion to approve? Second.
I have a motion by Commissioner DeChara, seconded by Commissioner Hills, that the minutes prepared and presented be approved. Is there discussion? Are there changes or additions? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, for the record, now, we've got an assistant commissioner with the Department of Commerce and Insurance who wants to Skype in here today, whatever that means. And fortunately, Brooke knows what that means, and she's about to set this up. So if you all will stand by for just a minute, we'll get this done. This guy's like 33 years old, okay, so don't, but he knows people.
Knows a lot of people.
Apparently, he knows the governor pretty good.
We're waiting for them to come online again. They are currently open.
You want us to come back to it? Well, we'll move on as soon as you hook up. Next on the agenda, we have an informal hearing for Bill Don Featherstone Senior. Are you in the building, sir?
I think he's no longer coming.
Okay.
I don't think he's coming anymore.
So should we take him off the agenda at this point? Or
Malcolm, you're sure he's not
Yes,
coming?
take him off the
Yes.
agenda.
Okay, we're ready.
And the commissioners can look right here, and the public can look behind you guys.
Thank you, Brooke.
Okay, Caitlin needs to, oh, there we go.
Can't hear you.
All right, let's try that again. Ah! I'm unplugging things, I'm sorry. We're good.
All right. Morning.
Morning.
Morning, Brian.
How's everyone doing? I can see you all, and I can see me, which is kind of scary. So, well, good morning, y'all. Thanks for letting me jump in with you this morning in Jackson. It's good to see everybody. I can see a number of you all there up on the panel, so it's great. I know really the goal here was to try to see how this process works and to kind of see if we can make this a potential option for you all in the future in terms of using kind of some alternative methods to be able to have folks chime in. So wanted to try it out. I know when we're in Nashville, I think we'll have a little bit more ability to kind of make sure the equipment's a little more prepared for this, but we want to be able to do this as an option for you all, both here in Nashville and when you're on the road in places like Jackson or other places in East Tennessee or West Tennessee. So really that was my primary goal this morning, was just to come in and chime in to say, to test this out, see how it works. But obviously I'd be glad to answer any questions or any comments y'all would like to have on any particular subject.
Questions for Commissioner McCormack? I have one.
Sure.
Do you have tickets for tonight's game?
That's funny. I was going to the game, but I'll be going to my fiance's sister's Cinco de Mayo party instead. So.
Fiance.
I think I'd dump that girl. You can go to the Predators, or you have to go with your fiance.
Yeah, I'll probably be watching the game on my cell phone at the party. So that's probably what I'll be doing. So thanks.
Commissioner McCormick, you need to get your priorities in line. And you need to also see, I've got my Predators tie on right here. So
Okay, I wish I could see that. I can't quite. I think that sounded like Commissioner Wood. I can't see you. Okay,
it
there you
was,
are.
it was.
There you are. Well, that's great. I'm glad you're representing. Morning.
What'd you do with your tickets?
Well, I sold them. So, yeah. No.
Commissioner Grease should always be your first call when you have extra tickets for the
Okay.
Reds.
Yeah.
And Bobby Wood right behind me.
Yeah.
Got one in the
Good,
back.
good.
Hold on one second. Now, this is a little extraordinary, but so is this Skype presentation, so come right up and have a seat here in front of this microphone. Hold on, we gotta get him back online here.
There he
Okay.
is.
Sit down and talk in that microphone right there.
How you doing today?
Good morning.
My name is Ed Apple. I've had a license for 50 years, and during that period of time, I think once my license had expired, and I didn't realize it till like 2 months ago, and my secretary failed to send in my annual renewal. And so when they informed me that I could be reinstated, I was real curious as to who set the fines for the reinstatement. It was $980 for me to be reinstated. And that just seems like it's really an unusual high amount to,
Let me, Mr. Apple, refer you to our attorney. I think she'll tell you it's by rule or by statute, but
Yeah, the fees are, the late fees are set by the commission in rulemaking process.
any chance of you all reconsidering? And I just think, either they need to send out another notice, in 6 months or something and cap it at 500, or we, ignore the second notice and, pay $1,000. But if I'd been notified that it hadn't happened, of course, when you get my age and you rely on someone else to take care of your paperwork, sometimes it doesn't happen. But anyway, I just thought it was a little high.
there are likely several people in this room today that agree with it. It
I
happened.
started not saying anything, but I just it does rub me the wrong way for that type of a fee or penalty.
Yeah, if it makes you feel any better, it's consistent across the board.
Yeah.
Okay, it's not.
Well, I believe that, but I mean, anyway, that's my heart.
Thank you, Mr. Apple.
Thank you for sharing, sir. Thank you.
All right, other questions for Mr. McCormack? Gary Bloom.
Well, Brian, are we utilizing the Skype as a potential substitute for bringing people to Nashville?
I think we wanted to, Commissioner Bloom, I think we did want to see what the option is. I think we had talked about, I think one of the primary considerations we were discussing, and I think we're interested in considering it for all parties, but one of the primary conversations relates to the brokers who may be representing an individual who might be applying. I think that was one of the primary points, because we're asking that person to come from their particular area. And really, it's I think we wanted to try to provide potentially an opportunity for a broker who wants to vouch for someone, an opportunity to not have to make the trip and potentially still have the ability for you all to see and interact with them and have the opportunity to still have a face-to-face conversation without maybe making it as burdensome for the broker potentially. But that's the consideration here, is for you all to see if you think this could be a potential option to handle certain types, some of your appearances or all of your appearances through an electronic means moving forward.
Well, I think it's a great option for formal hearings too, for people who have to be teleconferenced. This is, at least we can see their face, and that makes a difference.
I think we want to make sure we try to use, as we have technology and moving forward, we want to try to take advantage of the opportunities of the technology to kind of help us make this process more efficient for you all and moving forward.
So my last question, we'll let you go, Brian. So we have somebody on this end who knows what she's doing when it comes to Skype. It would take somebody on your end to know, like Caitlin, maybe you know about Skype, but some of these brokers you're talking about that were mentioned don't have a clue what the internet is yet. So it would have to be selective, right? I mean, we can't just, go ahead.
In terms of, we would obviously want to develop a kind of a practice of how we do this, make the information available, what's the process for how we would do it. I think we could make it as, I would suggest there would probably be a kind of an opt-in process. I mean, we're not going to require, if people wanted to attend the meeting, obviously they're still welcome to do that, but if they wanted to take advantage of the technology, we could have kind of step-by-step directions, and our staff here, Brooke, Director Young, they could kind of help us coordinate a process that we would use to allow to get that information perspective, folks who would participate in the process.
Are there other commissions using this technology?
I think it's something that we're sort of testing with you all in terms of this process, as you all have a lot of folks that appear, particularly as brokers, but I think it's something we're interested in kind of trying. You've got a director who I think is very interested in innovation and kind of taking advantage of all resources, and so I like testing things with Malcolm in various areas, because I think he's someone who's really interested in kind of embracing all the various tools that can make this process better for you and for your licensees.
Anyone else? All right, Brian, I hope you have a big time at your Cinco de Mayo party.
Thank you.
Watching your phone.
Yeah, exactly.
Listen, hey, Brian, we've got one more member of the audience who has a question. Sir, if you can come up. If you'll give us your name.
Oh, my name's Raymond Burside. I'm like the last gentleman. I failed to renew my license on time. It was my fault. I didn't do it intentionally. My whole question is, how many of us have had a speeding ticket? What do you do when you get a speeding ticket? You either go to court or you pay the speeding ticket. So I paid my fine. My question is, why do I have to come to this meeting?
Again, I'll defer to council, but I believe it's built into the rule. Is that correct?
Yes, the commission voted to put that as a requirement in the most recent rules that went into effect in October.
And, to me, it just looks like punishment. I mean, I've paid my fine. The other question I have, much like the other gentleman, if you go to the doctor and you don't pay your bill, they'll usually call you. And if you don't pay it then, they'll turn it over to a credit agency. I would have liked to have gotten a phone call. If I would have gotten a phone call, I would have taken care of this matter right away.
We understand your position. We hear it often. But I think this commission at this point has taken the position that licensees are their own business people, and we're not. We send out a notice as a courtesy, but we don't feel it's our responsibility to follow up. We think that licensees and their principal brokers ought to be responsible enough to take care of that issue. I'm not saying you're not responsible, but I think that's the sense of this commission over the last several years.
I just look at it as business. You give a courtesy call. Y'all are here to serve the people of the state of Tennessee, and you're also here to serve the real estate brokers of the state of Tennessee. My other question, is there any way you can repeal the fact that the real estate agents have to come to this meeting once they pay their fine? What is the use of us coming to this meeting, sir?
Well, the goal hopefully is that you'll find it educational, interesting, and perhaps you'll learn something. Not necessarily about when your license is supposed to be renewed, but other aspects about the business as well. That's why, well, that's not why we put it on YouTube, but there are people across the state that watch our meetings, especially educators, to see what we're talking about and what's trending as far as the real estate industry.
And, that's well and good. If I wanted to watch it, I'd watch it on YouTube. But instead, I had to take a full day's off of work, drive here. To me, that's punitive. That's just really, I can't understand it. I mean, y'all should have the decency to repeal that. But like I said, once again, you get a traffic ticket, you pay it, They do not make you go to court and sit there and watch the judge carry out his duty.
Your point's well made. We've received it. Thank you, sir.
Yeah, you're welcome.
All right, other comments before we let Mr. McCormack go?
Well, got another one back there.
Sir, we've got time for one more. If you'd like to come up and identify yourself, we'll let you make your comments. Again, this is not typical for Real Estate Commission, but neither is this Skype presentation with the commissioner looking in, so it's good to hear from you.
Good evening. My name is Glenn Chambers. I've had my license since 1980. I'm from Chattanooga, Tennessee, and I paid my license late. I called the I guess TREC office, and I asked them how long would it take me to, what's the time frame in regard to getting reinstated, and they were telling me it would take anywhere from 5 to 20 days. And I'm saying, why would it, I know there's a process, but why would it take that kind of time for you all to notify me or my broker that I've been reinstated?
Malcolm, do you want to speak to that?
Thank you for your question this morning. I will tell you that I'm real excited to tell you that if we're having this conversation in about 60 to 90 days, that that answer is going to be totally different, because come June the 22nd, we will be hopefully fully automated with our new core system, in which it will be on real time, in which you can go online and actually do these transactions online and instantaneously have reinstatements and have address changes and things of that nature. So right now, we're manually doing it under the old system, but as I said, we are making good strides to automate the systems within the Tennessee Real Estate Commission.
And Mr. Chambers, Brian, do you want to speak to that as well, just globally, as far as what the department's trying to do?
Yeah, one of the things we're committed to is making sure that the process, we've been working pretty hard to make sure that the time on this process is improved. It does require some time, as this is manually entered in a lot of cases. We've moved to the new, as I think Malcolm pretty well articulated, but we've been moving to a new system that's allowing for much greater opportunity for individuals to do a lot of the work themselves to get that information, where our turnaround is going to be much quicker because the data is being provided to us in a way that allows the turnaround to be much greater. And so I think we're going to see, we've already seen some improvement over the last number of months and with some of the implementation pieces we've done, but I expect that licensees will have, particularly as we move forward, we're really moving into an area where getting access to your license, getting access to reinstatements, those things will be able to be done much, much more efficiently as we automate the system more completely. So, we understand the concern that was expressed, and it's one that we are diligently trying to get done. I will say that one of the tools that we have in terms of that you have in terms of if your license has been reinstated, sometimes folks have to, you wait on their certificate that comes in the mail to say your actual printed certificate. One of the things you can do is go to our website where we have Verify TN, where you can go and check the status of your license. And we often encourage brokers who have individuals look at that to go to look to see, hey, is your status been updated? And that's often quicker. It's done as soon as it's approved, it's updated. And sometimes that'll happen a little bit quicker. And I know our staff is glad to make sure to notify if you have some questions, or you have a broker who needs that information. We want to help you get to work quicker. So, we do have some other methods that might be a tad quicker than getting your certificate printed to know that you're actually licensed.
So just to be clear, so if the license is suspended, the license is still hanging on the wall. Let's say somebody forgets to pay the renewal fee. They pay the renewal fee, they come to this meeting, then almost instantly on Verify 10, it will show as active.
Correct.
That's correct, and they're good to go to work.
You don't have to wait for a certificate to get to you. If it shows posted as active on Verify 10, you're active. So
Correct.
you're not waiting on the mail anymore necessarily for a certificate to show up before you can start working. Correct, Malcolm?
That's absolutely correct.
I'm just reacting to what I was told when
Sure,
I called.
sure.
They gave me the time frame.
But this commission, the Department of Commerce and Insurance, with all the different commissions they have recognized this topic as an issue, and they're making great strides, I think, to try to get it down to just a short
So what
period
you're
of time.
saying basically is that when I leave, well, tomorrow I should be able to conduct business somewhat.
Brooke, you want to just, you're shaking your head, within a day, go ahead, Brooke.
The reinstatement process, because this is an away meeting, we will bring the paperwork back to our agents. And generally, we say within 2 to 5 business days. It just depends with this being an away meeting. However, we are very normally quick to do it, and we've got some wonderful agents doing it. And as soon as you're active on the website is whenever you will then be able to conduct business.
Yeah, the people today that are here for expired licenses, we're going to do our best to have it turned around at least by Monday, because we'll be traveling back tonight, and it will go into process tomorrow.
By Monday.
Thank you, Mr. Chambers, we
Thank
appreciate
you.
it.
And Chairman
Right.
Grease, I just want, if I could, just chime in on one more subject. I know that I understand that you all are probably going to have a conversation on the subject of reinstatements and appearances, and I can guess you can imagine sort of where I stand on this. But I'm sure, I don't know if you've taken that subject up, but I will strongly agree with your legal counsel's primary recommendation. So I know that's going to come up, and it's already been mentioned by a couple members of the public. So since it's come up while I've been here, I wanted to let you all know that I do support what legal will be recommending to you today.
All right, Brian, thanks for Skyping in.
Thanks. It's good to see you all. Have a great meeting. Thank you.
Thank you.
Bye. All right, we're going to move back to the agenda now. Under the topic commission discussions, 2017 proposed legislation. Malcolm, are you leading this discussion?
Yes, sir. Although we've just completed the 2016 legislative session, in fact, at your next meeting, we will have a comprehensive report, not only on impact on licensees, but also impact on real property and also the appraisal specialty of the outcome of the legislature. So look forward to that in July. However, one of the things that has been asked by the division is that if we anticipate any legislative changes or anything that we want to propose in 2017 as a commission, they are asking us to provide input. In fact, on part of your iPad is a form in which there's several questions asked of you in consideration of the 2017 legislature, if there's any to be considered at this time.
All right, commissioners, you have thoughts on legislation you might like to see passed that would affect the real estate industry and the public?
Where is that on our iPads, Malcolm?
I believe it's like the third, it's about the fifth item down. And I will make a note that I'm sure many of the commissioners are aware that the Professional Association, the Professional Association for Licensees, the Tennessee Association of Realtors, that they do have I believe, a work group that's working during the summer on education proposals. However, this doesn't impact our deliberations today on legislation, but I did want to make a footnote that they are having those discussions as well.
If y'all are thinking about it for a second, I've got a couple of things I wanted to mention about legislation. One is that, like Malcolm said, we'll be going over a more comprehensive list of those statutes that have been enacted this past session that affect the real estate industry. However, we have one change that was a direct change to our Broker Act, and that is that the previous requirement, well, I guess it's current, I don't think it goes into effect until maybe July, but The current requirement when you put your license in retirement is that you have to fulfill all your educational requirements before you can do that. That has been changed by statute so that you do not have to do the educational requirements to go into retirement. You have to do them to come out of retirement, which I think makes a lot more sense. So that in essence gets rid of inactive status altogether. So that's the one direct change to our Broker Act. The other thing I wanted to mention was I had a thought that because I see this issue coming up a lot in complaints, not in just complaints, but also attorneys and licensees calling me and asking me about this, is the whole LLC licensure issue. I think it may be something we want to consider codifying what we already kind of put into practice and what we've been told by the AG's office, which is that LLCs do not fall under the owner exemption. They have to be licensed, but I think it's not clear in our statute, and so a lot of licensees are in violation of that without knowing it. And also many attorneys, after looking at our code, don't come to that conclusion either, so that may be something worth considering. And also possibly my thought was is to propose maybe including an LLC in the corporation exemption, which is a very narrow exemption, but it essentially says if your company, well, right now it says corporation only, if your corporation owns property and selling real estate is not its primary function and you just are trying to dispose of the property, that somebody that works for your corporation can sell the property without a license. So that's just my ideas. Y'all can think about that and discuss it if you want to, but.
Other commissioners? So this is my annual plea, not really a plea, but so basically this commission has no authority over people who sell real estate without a license, unlicensed real estate salespeople.
Other than you mean you can discipline them for unlicensed activity, but beyond that, no.
So if we discipline, they don't have to, if they don't want to pay it, we can refer it to a local district attorney at some point.
It can be, I believe it's a Class C misdemeanor. It can be referred to the district attorney's office.
That district attorney's got murders, rapes, meth problems, and the
Yeah.
fact that somebody's selling real estate without a license doesn't make it very high up on his list of things to
That's
do.
most likely true.
So
yeah.
legislatively, is there something that, or statutorily, that could happen that would give this commission some teeth when it comes to working with people who are selling without a license?
I don't think so. I mean, generally what happens is they're issued a civil penalty, and then if they don't pay it, I mean, they get sent to collection. So it does affect them. It's not like they just walk away with no, punishment at all. But
I'm gonna pull a Dave Flickcroft out of my hat now, because Dave was very big proponent of making a stiffer penalty for that. Oklahoma now has passed legislature to make it a felony, and they can go to jail for practicing real estate without a license. That's what we learned at Arillo.
okay.
Is it the same thing if I practice law without a license?
In Oklahoma?
Tennessee.
Don't
You mean the
do that?
potential punishment for it? I don't know, to be honest with you. It's probably something, I mean, I know it's a crime. I'm not sure what level of crime it is. But, I mean, I'm sure the Board of Professional Responsibility can issue civil penalties for that as well, similar to what y'all can do. So, but I don't know specifics.
So we have some time to think about this. Or do you need?
If you have any ideas today, that would be great. That doesn't have to be solid, set out things. If you have ideas right now, that would be great to let us know. Otherwise, we can talk about it again in June.
Okay.
So the proposed legislation, I have been a proponent for years on taking away grandfathering. I'm opposed to people not being educated, and especially if they're principal brokers. So that's always been up to the legislature as to when, and that line moves that date of, you're grandfathered up to 2008 now, I believe. Is that correct?
2005.
Five? as we have attended the Arello meetings, I can tell you, there's no one doing that except for Alabama. Alabama still has a handful. We are the only state that is doing that, and people always are like, why would you not want education, especially for a broker?
Sure.
In the past, we've been told that's up to the legislature, so if this is our open door to give suggestions,
Yeah.
it would be, my number one thing would be, and especially if we're trying to protect the public, and that's the oath we took, it was not to protect realtors, actually, it was to protect the public. That, and we see it in all of our meetings of people who come in who are the principal brokers and haven't had a class in 15 years. And as a principal broker myself, you know, even coming to the real estate commission meetings every month, there's just so much to know. And if you're not keeping up by going to a class, then you're probably doing something illegal as a principal broker. And that's not good for the broker, it's not good for their agents, and it's certainly not good for the public. So I would definitely like to have that on your list, if there's anything that we can do
Okay.
as far as doing away with grandfathering.
Okay. Another thing that they're gonna ask me when I bring the proposals, the potential proposals, is it something that the commission as a whole is wanting, or what is the source of it? So it may be, I don't know if we wanna take a vote or just generally discuss, if that's a commission position as a whole.
Well,
That's something they're gonna ask me.
Because we don't get to talk about it anywhere except here.
Sure.
So I'm not sure how the other commissioners even feel about the grandfathering. I'm sure there are people who are opposed to that, but this is our only platform of even knowing what we think. So I would be interested in knowing what the other commissioners think and feel
Okay.
about that.
Well, I certainly support Marcia's position on that. In fact, that's one of the main focuses I've had ever since I've been on the commission.
And I do too. I support it very strongly. I have seen, having been a principal broker, I have seen the fallout, I guess, for working with agents or brokers that have not taken any education except now the required course every 3 years or something. It's amazing.
Are most of us grandfathered here?
I'm grandfathered.
I am.
Me.
I am too, and I do support it. So it's not coming, so when we say that, my point is, it's not coming from someone who's not grandfathered. You know, I think most of us all are grandfathered.
Okay.
John,
Johnny?
as a point of interest, I have a grandfather, so I know what grandfather is, but what y'all talking about right there. I'm having just a little bit of a problem. Now, grandfathering is supposed to allow somebody who has been in business before you put your laws in to continue to operate in that particular way. Well, wouldn't there be a time limit on from the time that the grandfather clause was issued up until the law was put in place? I mean, what I'm saying here is everybody raised their hands that they were grandfathered. But sooner or later, the grandfather clause has got to run out. Now, I think that's what we ought to.
When you consider all of the when you consider all of the brokers who are grandfathered since 2005,
It's before.
that's thousands of people. So if you're going to wait on all of us to die off, that's a long time.
There are currently over 6,000 people who are grandfathered because of the 2005.
Yeah, I can see the enormous situation, but what I'm talking about here, shouldn't we put something in effect that grandfathering could last? I mean, maybe somebody else has to do that for so many years, and then after, instead of just saying your grandfather forever, that's
So,
my.
yeah, so what's the benefit of that? My whole aim is that everyone needs to have education. Everyone. And especially the principal brokers who are in charge of their offices and their other agents. You cannot tell somebody or guide somebody if you don't know what's correct. It's just, and it should tell us something, that we're the only state that's doing that. I mean, that's huge in my eyes, that no one else, I mean, in Arello, there's Canada, there's people from, they have none. And this grandfathering date has been moved several times. It started out, I don't know, maybe in
86, I think.
and now it's moved up to 2005. You know, who knows? We could have new legislation. They move it up to 2015. I just think that if we were sworn to protect the public, and that is not protecting the public to say, okay, principal brokers don't need any education. They're the ones who need it the most.
I'm just doing some quick math. My math is about right. That means a little over 20% of our members, our active licensees, are grandfathered now. So that's a bigger number than I thought. Bigger number than I thought.
Which creates a big problem. You're going to have to get the trade association, the Tennessee Association of Realtors, unified in any type of effort to get grandfathering removed in some form or fashion. Because if 20% of our members are grandfathered, they're going to be at least 20% of the membership of the trade association. They're going to fight it. Then the issue gets to the legislature, where I think just about everybody up there has a real estate license, and none of them want to do education. They just have it. Okay, so I think it's, you know, we can talk and say it's a great idea, but the reality of getting this done is slim and none, in my opinion.
But doing nothing is not, I think, something that this board should support.
Well, I'm not saying that the idea is not good, but I'm thinking myself, the administration, if they have to take something controversial up to the legislature, would just as soon not take it up to the legislature. They got other more important issues they're trying to get consensus on.
Well, what is causing more damage, the grandfathering or the LLCs being unlicensed people? I mean, what are we seeing? We're seeing people come in here and they don't know why they didn't get called or what the process is. They don't know.
I'm not arguing. I will tell you, the only study I've ever seen done on this was done in the state of Kentucky. And the state of Kentucky said a majority of the complaints they got on licensees in Kentucky were from people who've been licensed for less than 3 years. Who are educated.
Go back and look at our legal report. 90% of ours are grandfathered.
I don't believe 90% are grandfathered.
And I would say, when you're looking at the 20% rule, there's probably 20% of this crowd here today who is grandfathered, but yet they're still here. I think people who are active realtors realize the importance of having education and knowing what's going on. But I think at the minimum, we need to have principal brokers required to take education, period.
And just to step outside this conversation for a second, for the audience's benefit, as Ms. Franks alluded to earlier, we can only have this discussion in public. We cannot talk between ourselves on the car ride over here, by phone, when we're not meeting. So some of you might think, man, they're wearing this thing out for no good reason. Well, it's the first time we've really had a chance to talk about it. Valerie.
I'll also mention too, so the department gets proposals from all the boards and commissions and then kind of decides which ones the department is going to go forward with for the legislative session. And the factors that the department uses in selecting which proposals they go with, a lot of it has to do with whether they fall under the governor's priorities, which are education, job creation, effective and efficient government. All that to say, we'll definitely propose anything you guys bring forward and let them make that decision. But this may be something that may not fall directly under one of those categories, and so it may be something that if the association wanted to bring it, then they would have to, they could do that. But I'm not for sure that the department would, necessarily move forward with it, since it's a little bit not directly tied to one of those priorities. So.
Okay, other comments? So let's, you've got a sort of an outline Ms. Kirby, and we may want to expand on that outline in June.
Okay, so right now I just have the grandfathering issue and the LLC. Is that all we have at this point? And then we'll rediscuss in June?
Practice of real estate.
The education, after you take your license out of retirement, instead of when you put them in retirement, is that part of it?
That just passed, this
That's-
past
Okay.
session, so that's current, well, it will be current law when it goes into effect. I think the effective date is July, but I'll have to double check on that. But that's
Okay.
already been through the legislature.
All right, if there are no other comments, let's move on to the next item, which is a discussion about the core education outline for 2017, 2018. Malcolm?
In May, we started this discussion. We've also asked for input, and also loaded on your iPads today is suggested topics, and hopefully we could get a motion from you today to adopt the core topics for 2017, 2018, which is the next cycle. And it's actually listed on your iPad called Topics for TREC Core Course for 2017, 2018.
So, go ahead,
Mr.
Marcia.
Chairman, I didn't see anything on here, concerning teams.
That would be
Is that-
under the
Actually, that'd be under
Just supervision?
advertising, Commissioner Franks.
Under advertising.
Okay. Okay.
So, am I misreading this, or are you all proposing one core course that includes both residential and commercial? Or do we have two separate core courses, one for residential and one for commercial?
This one's just residential.
It's-
The second page.
Just says
is commercial.
residential. We have separate ones, and I think it's important that we keep those separate because it's actually two different.
Oh, there are two.
Got it.
You just
Okay.
need to go to the
Thank
side.
you.
The side.
My finger wasn't working.
I think it has to be turned long ways, and then it goes, and then
So,
There you go.
other comments about the outline for these two courses?
I would make a motion that we approve this outline for the 2017-18 core course.
I have a motion by Commissioner DeChara, seconded by Commissioner Taylor, that the outlines as submitted by staff to Commission today be approved.
Can I ask a question?
Yes, sir.
And I've scanned it, but is there anything in here regarding handling multiple offers?
And I have gotten a call about that just within the last couple of days too. I think it's something that we're starting to see a lot more of again and probably needs to be incorporated somewhere.
Okay, and then the other thing is, would it be, I'm seeing in my market area, the use of the practice of using coming soon signs. And I'm wondering if it would be good in the core course to talk about if that can be done, how that's to be done or can be done.
Under advertising.
Would that be part of that?
I mean, it should be,
Okay.
I think.
And I
I
think the
agree.
multi-offer should probably go under contracts, Malcolm, if we can make sure that that's part of that discussion.
So do I need to make that, Commissioner Grease, as an amendment?
I think what
Or
we
you
could
like
do is
that?
just, it's a friendly staff amendment to make sure that we add that into the list.
Okay, good.
And where is contracts on this?
It's number 4.
Okay.
Okay, so without objection, we'll ask staff to put some language related to multiple offers under contracts and coming soon under advertising.
Okay?
Without objection, make sure there's no objection to that. All right, we still have a motion on the floor, but we'll entertain more comments before we vote. All right, since we're ready to vote then, you've heard the motion offered by Commissioner DeChara, seconded by Commissioner Taylor, that these outlines be approved as amended. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Next up, proposed does the word expired mean we're not handling it, or what does that mean in this
Well,
outline?
wait a minute. Do we need to have a separate motion for the commercial
I,
Core, I thought we
Twice.
accepted it
I think-
both together.
Yeah.
We had two different ones. I thought we accepted the commercial and we accepted the residential
That's my sense
at
of
the
the
same
motion.
time. That's what I thought.
Tell me what that word expired means, Malcolm.
Actually, this has to do with proposed language of council having to do with at your last meeting, you asked for proposed language from council having to do with options of licensees with expired licenses actually attending future meetings. So you may want to turn that over to Ms. Kirby.
Yeah. Okay, so you have on your iPads, I believe it is, let's see, number, where is it? Well, it should be on here.
Reinstatement.
12?
It's reinstatement.
Oh,
meeting
it's number
requirement.
5. It's number 5 on your iPads. I drafted 3 options. Last meeting, you had asked me to draft some options for the removal of the meeting requirement for reinstating expired licenses. So I drafted 3 options for you here. The first one removes the requirement altogether. This is my strong recommendation to you, to just get rid of the meeting requirement, to have people pay the late fees if their license is expired, and that's it. That is what I think is the best choice. There are 2 other options. The second one is to give a choice between attending a meeting of the commission or doing a continuing education course on license rules and laws. And the third one, which was based off of some suggestions by the commissioners at the last meeting, would be to view a meeting of the commission on one of the YouTube videos and write a one-page summary on a matter that was discussed. So those are the 3 options I drafted. Again, I would strongly suggest the first one, but I will leave that to the commission to decide.
Would you like to go through your recommendation, number 1, just to maybe highlight a few of your thoughts
Sure.
on it?
Right, okay, so my thoughts are essentially what was articulated by the gentleman that came up and spoke earlier. I understand the commission's view that the coming to the meeting is educational and you can learn a lot of things here, and I agree with that. However, I don't think that directly correlates to forgetting to renew your license. And so I think that, like the first gentleman said, paying $900 or however much it ends up, depending on how long your license has been expired, is sufficient for giving them the clue that they need to keep better track of when their license expires.
So what we've been doing lately, it seems, Chairman Grease, have been giving the option of come to a meeting or to take a specific class on some of these things. I don't think there's really a specific class on your license not being timely renewed. So I would agree that it is, the meetings take place in Nashville. I'm from Franklin. It takes 45 minutes for me to get to the meetings. We had a gentleman a couple of months ago who was from East Tennessee who couldn't afford a hotel, and he had to sleep in his car. So the punishment on him versus what would be for me would be much more severe than for me, and I think it needs to be equitable across the board. And I would agree with our attorney in that option 1 was probably the best option, in my opinion.
And remember, this is a proposed rule change.
Mhm.
So I think at the end of the session, if this commission is in agreement, we'll instruct Ms. Kirby to start the rulemaking process. That's the intent here, if the commission thinks it's appropriate. Other comments?
Motion.
Ms. Hills?
I motion that we accept option 1 and for Ms. Kirby to go forward with that.
Second?
Okay, I have a motion by Commissioner Hills and seconded by Ms. Franks, and I believe the intent of that is to instruct legal to start the rulemaking process with language identical to or similar to option one that was presented to us today. Let's discuss that motion.
So option one, just to clarify, gets rid of number 3 in the rule there in 1260-01-.212B, number 3. It just eliminates that.
And remember the others, yes.
Everybody understand the motion? All right, since we're ready to vote, let's do it. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thanks, Ms. Curry, for putting that together.
Certainly.
All right, we also asked about the potential of trying to clear up a few backlogs on formal hearings by perhaps meeting in December. Ms. Kirby?
Sure. Okay, so Richard Collier, the head of the APD, got back with us on some dates that are available in December for hearings. And he has said that there are 2 weeks that are available, the December 12th through 16th or the 19th through 23rd.
No.
And my understanding is that the commission can pick any 2 days within either of those weeks that we could set hearings for.
So I sense it won't be the 19th through the 23rd.
That's probably
We probably have some
good choice.
things to do that week.
And it's not a requirement we pick any date, to tell you the truth, but if the commission is inclined to do so.
And could we, if we do pick 2 days, we could actually have hearings both days, correct?
Yeah.
What is the backlog? How many?
Well, I think according to what Sarah, the attorney, the litigating attorney that spoke last time, my understanding is that all of the dates for 2016 are full at this point, unless we add these December ones. So the hearings won't be being scheduled until 2017.
I'd like to make a motion.
And also, if you just want to pick one day, that would be fine too. That was just, we had talked about before, a potential 2-day meeting. So it's really just whatever the commission prefers.
I'd like to make a motion that the commission meet to hear cases on Wednesday, December 14th, and Thursday, December 15th.
Second.
All right, so just speaking selfishly, I can't be here on the 14th of December.
Okay.
I can be here on the 12th and the 13th, but I can't be here on the 13th and 14th. So
Okay.
Just out of curiosity, for those of you that travel, is it better if we were to do it a Monday where you could travel on a Sunday?
It
I'm
would
just-
be for me.
I'm totally open to that.
Yes, it would be
With
for me.
12th and 13th, okay?
So if we did,
And
Then y'all tell
us.
and personally, and that does help me, personally, it seems like I have more social events the 12th through the 16th, even though they're not on my calendar
Okay.
yet, than the week before Christmas, like the
Okay.
19th through the 23rd. It's usually a quieter time, it's just my last minute. But that's me. I don't know about your events. But it does help me if I could travel on a a Sunday, that does help.
I'm fine to amend that motion to Monday, December 12th, and Tuesday, December 13th. Does that help you, Chairman Grease?
that works for me. So is there a conflict among staff or commissioners for the 12th and the 13th?
No, sir.
Not that I know.
All right, we'll accept that motion or amendment to the motion. So meet in Nashville on the 12th and 13th of December. That's the motion for the sole purpose of formal hearings
Right.
at this point.
And Commissioner Hills, is that going to conflict for you?
Now, that works. I don't know my social calendar yet, but that works.
It's
That
mighty
does-
full, I'm sure.
All right,
That
I think
works
we've
for me,
discussed this
thank you.
enough. Let's vote. If you're in favor of the motion, vote aye.
Aye.
Opposed, no. Motion passes unanimously. Let's take a 10-minute break. I've taken the parking. Take me one, where the parking are, so if you will. All right, ladies and gentlemen, we need to get back to work here. Next on the commission discussions portion of the agenda it relates to ARELO, which stands for Association of Real Estate Licensed Law Officials. We are licensed law officials because we're members of ARELO. There's a meeting coming up June 1st in Oklahoma City. Malcolm, what do we need to do?
Well, as a commissioners, and this is noted in your iPads under 06 ARELO OKC 2016. One of the things I wanted to bring to your attention today, it is on June the 1st through the 3rd. However, we do have a regular scheduled meeting scheduled for the 1st and a hearing scheduled on the 2nd. And the bulk of the meeting as far as substance would be taking place on the 2nd. But due to the fact that this is where a lot of the governance issues for the district take place, where commissioners have the opportunity to be elected as a director to ARELO, I felt like I needed to bring this agenda to you just in case there would be anyone that would want to attend.
Thank you, Malcolm. Commissioners? Well, we only need 5 to have a quorum in Nashville, so if one or two of you feel strongly that it would be good for this board or commission for you to attend, let's hear it.
Well, of course, Marcia and I just attended ARELO with Malcolm and Mallory, and Tennessee does not have a voice because we do not attend this district meeting usually. And Malcolm and I talked about possibly one of us missing the hearing on the 4th, but it would certainly we'd have to know how many other commissioners are going to be available to be there on the, at the commission meeting on the Thursday so that we didn't run short.
That'd be the 2nd.
First and second.
Yeah,
First.
the 2nd.
You want us to take just a quick sample? Is anybody not counting on being in Nashville early June 2nd, 3rd? I'm sorry, 1st and 2nd, no, 2nd and 3rd.
No,
First and second.
First and second.
As I said, 1st and 2nd, the second time I said it wrong. So I think we'll have a quorum.
I will say this about ARELO. I received an invitation yesterday from the president of ARELO, Craig, what's his last name? Coffee? Yes. I'm attending the NAR mid-year legislation sessions next week, and ARELO is going to be meeting with the NAR leadership, and he invited me to attend that with him, so I'm going to be doing that. I also plan on going to Vancouver to that meeting in September. So we did have a voice on the board of directors in Eve, but when she left her position, we'd lost that director. So I do think that's, I mean, it's where the votes take place, and it's I think it would be important for us to have somebody at that meeting if possible.
I've never been to ARELO, but I think it's, and I certainly shouldn't go, I'm not saying that, not to that meeting, but I certainly think we should be represented, very much so. But I also think that, as I understand it, we only can have full members at a full membership that are paid for to go. And if you get staff, that leaves only 2 members to go, and I think that that's a mistake also.
Well, I think in this particular case, I'd be surprised if staff would be available to attend unless you went to the last day of the meeting.
No, I would definitely feel like that my priorities need to be with the commission on the 1st and the 2nd. So it would be up to one of the commissioners to represent us at the ARELO Oklahoma City meeting.
I would think that one of the 2 commissioners, which is Diane or whatever, that goes to the meetings that have been to the last, 3 meetings or 4 meetings? I think that one of those would, or both, would be the ones that we would send.
And we would have to ask the state as to whether they would fund it or not, is that correct?
That is correct.
Assuming funding, Ms. Taylor, would you like to make a motion?
Well, I think I need to have a little bit more information because since they both have been, I think one of them should say which would, I think they probably need to know who would be the better choice
Well,
to go.
in a situation like this, if we have 9 members and we end up at a meeting with 7,
Mhm.
we're still in good shape. So if both went,
Oh, all right.
if they both wanted to and chose to represent Tennessee Real Estate Commission, I'm very comfortable with that, especially since the board has indicated, or the commission's indicated, everybody expects to be present.
But Janet, aren't you on a committee?
Yes, Marcia
Okay.
and I both
Okay.
serve on committees.
Yeah.
Well, then I make the recommendation, but that both Janet and Marcia go to the June meeting of Arello.
Is there a second?
Second.
Okay, so the motion offered by Ms. Taylor and seconded by Ms. Hills says, subject to funding, this commission requests that Commissioners DeChara and Commissioner Franks attend the June Regional Arello meeting. Is there discussion on the motion? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, ladies. You guys have got to agree to do it too, by the way. So we haven't asked you that question, but
We can go.
okay, thank you. During the break, I had a comment from one gentleman who said he was having a hard time hearing. Is that true? You can't hear in the back very well? Okay,
Can the sound guy turn us up?
I will have to find out who knows how to turn us up, but we'll try to help you out with that. All right, now we're on to the Education Director's report. I understand he's had more surgery.
Yes, in lieu of Ross, you have me again to do the education report today. He had shoulder surgery last Friday. He is recovering. Friday a week ago. He is back in the office, but unable to travel to the meeting. And I have the approved courses and providers as a document on your iPad. If you would reference the courses and the instructors for review, and after review, it'd be appropriate for a motion to approve these activities.
Can I just ask a question?
Sure.
I'd like to know what the process is for approving the classes and approving the teachers.
The process is the course outline is submitted to commission staff. We look at the course outline according to learning objectives that are put into place as far as the commission, and that's what the basis is as far as approval, if it meets, if it covers rules and regs of the commission. And then as far as the instructors, one of the things that's not, it's not a set in stone requirement, but it's certainly an encouragement, is that the instructors have gone through the train the trainer courses that are offered twice by the Professional Association of the Tennessee Association of Realtors.
And that class is coming up at our association, at WCAR, I think, in 2 weeks.
Yes, ma'am. In fact, we have notified potential instructors as well as current instructors of that course offering.
So are you saying that is not a requirement now that they have taken that class at this point?
Well, what's interesting with the rule is they have an option that it says that they have needed to complete a course of instruction. However, if you look at the instructor form that's actually online with the Real Estate Commission, course instructors actually have the option of reviewing a Train the Trainer module online, which is on the which is actually on the TREC site, and they could actually certify that they have reviewed the Train the Trainer course, and that qualifies them to be an instructor.
And so would education degree also?
Well, it can't be in lieu of.
No, but I mean, could instead of doing the trainer, could they, I have a degree in education?
They
Would
could
that
do that,
serve?
but I would probably encourage them, as your rule states now, to actually do the online module.
Okay.
That is an official certification that they have completed the instructor training that is sanctioned by the Tennessee Real Estate Commission.
Okay, other questions? Is there a motion to approve the courses as recommended by our education director?
I have a question on 1073, course 1073.
All right.
Which one, Gary?
1073. What is CNE? Is that a proprietary kind of financing? CNE ownership.
Where are we looking? What page is that, Gary?
It's on page 2.
First top course on
Oh.
page 2.
1073.
I don't know what that represents.
It's from Chattanooga, so it may be Chattanooga's some kind of financing program. But if it's a proprietary program, we shouldn't be approving that.
I'm gonna Google it.
While we're working on that, just for a second, I'd like to mention that there's a distinction between the Tennessee Real Estate Commission and the Tennessee Association of Realtors. The Tennessee Association of Realtors is a trade association that advocates for the best interest of its members, realtors. The Tennessee Real Estate Commission, on the other hand, is the entity that grants real estate licenses and can revoke, suspend, downgrade those licenses. Many of you have already done this, but apparently your trade association, the National Association of Realtors, has a requirement for you to take an ethics course once every 4 years, and the end of that 4-year period is December this year. So I only mention this so that about December, when some of you guys start thinking about taking it, it wasn't us that caused you to have to take that course, okay? We didn't do it. It's your trade association. And just keep that in mind. Thank you.
Well, I'll just make a comment that if you belong to the Central West Tennessee Association of Realtors, because you're here today, that covers your ethics.
All right.
And the CNN stands for Certified Negotiation Expert.
And it is Chattanooga. Chattanooga. Oh, that's what I'm finding.
So I don't know what that has to do with home ownership.
I would probably suggest that, due to the fact of the confusion in this course, that we remove this off the agenda until June, until we could get clarification, because I have to agree with Commissioner Bloom. We would not want to do an endorsement of a product-specific course,
Okay.
if that would fit with you.
I'm going to interrupt again for a second. Mr. Chambers, it's not typical for this commission to get,
I'm from Chattanooga, and I'm familiar with that program.
well, in that case, as I said, it's not typical, but this is not typical. Will you tell us what it is? Come tell us then. We'd appreciate it.
It's Chattanooga Neighborhood Enterprise.
Okay.
What is it?
They help people with the down payment, and they also do financing also.
Oh, okay.
Oh, so it's kind of a
Thank
down
you.
payment
It
assistance
refers
type
to
program.
coaching? It refers to coaching
Chattanooga
online?
Neighborhood Enterprise, yes.
Okay.
So this course would be only taught in the Chattanooga area, then, I suspect.
Yes.
Okay.
Well, then I would not be opposed to that.
Thank you, Mr. Chambers. That's helpful.
That was very helpful.
I can ask a question.
Mr. Horn?
Is this done only for CNE, or is it open for other people?
Well, you have to, I think it's in the city area, because if the house is in the county, it cannot be financed through CNE, it has to be something in the city.
It refers to neighborhoods and things and what I'm seeing online.
It's in the city, yes.
Okay, but that's with C&E though. Okay, that's what I'm.
Okay, thanks to both of you. I think this commission has got the sense that this is a worthy course that ought to be approved.
Yeah.
Is there a motion?
What about Gary? Gary?
Oh, yeah, I'm fine.
Okay.
I make a motion, we approve courses M1 through M17.
Second.
I have a motion by Mr. Chara, seconded by Commissioner Wood, no S, that these courses be approved. Is there discussion? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now, what about the instructors?
I'll make the motion for approval.
I
Second.
have a motion by Commissioner Wood, seconded by Commissioner Hills, with an S, that instructors be approved
Wood
as
Hills.
submitted. Is there discussion?
Well, I'd just like to make a comment on the record that, Mr. Young, could you see that in the future on the, instructors that need approval, that we have some kind of background on them as to what qualifies them as instructors?
Yes, ma'am.
Thank you.
That'd be great.
All right, further discussion? Other questions? All right, let's vote. We have a motion to approve the instructors as submitted and recommended by our education director. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Education newsletter, Malcolm?
Just as a matter of information for the commissioners, I'm including the first newsletter of 2016 for the Tennessee Real Estate Education Update. This will also include the outreach courses that we have scheduled in August and September, in which Ms. Kirby and I will be going out to at least 7 sites and doing continuing education for licensees. So it's just a matter of information that's before you under the education newsletter.
Thank you.
May I ask a question?
You sure may.
Sorry.
No.
I don't see any West Tennessee, are we gonna get to West Tennessee?
Yes, ma'am. It's-
Memphis
On the
and
very first
Jackson,
page,
August
right
9th.
Oh, I'm looking at something else then.
You just
Got it,
skipped
I
West
missed that.
Tennessee.
Okay, got it.
Okay.
All right, Malcolm, let's move on to your executive director's report.
Okay, Executive Director's Report. I have filed with you the Arello mid-year report. In fact, some of the items of that report we will be taking up in later in the report, but I did want you to know that it does have some good information, especially one of the things that we did learn at Arello is the movement having to do with what I would call universal licensing. And of course, the topic of reciprocity was also one that came up in our meetings as far as Arello. But I will tell you that the 4 of us that attended, it was beneficial, and I do think that we have brought back some great information that will be moving this commission forward in the future. Also of note is under the Arello Fall Conference, we probably need to be thinking about the 2 commissioners that could potentially be selected to go to the Fall Conference in Vancouver, Canada. What we have done at this point is we have asked for a preliminary review and opinion from the Department of Commerce and Industry, and because one of the prohibitions as far as travel is that we can only travel to the 38 contiguous states.
48.
I'm sorry, 48 contiguous states. And although Vancouver is out of the country, we did put together analysis to demonstrate to the people making the decision that it is more cost-effective to travel to Vancouver, Canada than to the western part of the U.S. And they are taking this under consideration because the fall meeting of Arello in 2017 is in one of the 2 states that is not contiguous, which is Hawaii. So what that would do is that would basically knock TREC out of having any representation at the fall convention meetings for the next 2 years. But they are taking it under advisement, but they have asked that I come back to the commission and have suggestions of who the 2 commissioners would be that would be funded for that meeting in the fall if they were to approve it.
So, we're back to the similar question we had about Oklahoma City. Is that, do we have a time issue at this point, Malcolm?
No,
or-
sir, we do not.
So, if we said we'd like 4 people to go, is that good enough at this point?
I would say that they would, we did that for the Arello meeting in Atlanta, and I think that they would come back and say 2 staff members and 2 commissioners. So I would suggest that you probably stick with selection of 2 commission members.
And I would like to say that I'm on the program committee, and the program committee is the committee who chooses the spots and the locations, I should say. And I was very adamant in those meetings that we are not the only state that's under those requirements that we stay within 48 states. So we are looking at that. I'm actually really working on them coming to Nashville. They seem interested in that, but there's still more work to do on that.
All right, commissioners, any thoughts about who this commission would like to send from a commissioner point of view to Vancouver if we're allowed to go, which is still problematic, right?
We're hoping to get a ruling on that within the next 30 days.
Should we go to the mental exercise of doing this until you have a ruling?
You could wait.
And I would love for you to see that we asked for more
Yeah.
than that, because we used to take more than that. Have they said 4 people is all you can take?
I know that when we submitted for Atlanta, which is close, and we've also used 1 vehicle that we all rode together, and they still declined the 4 that we originally asked for Atlanta.
Well, last year, we took 5 or year before to San Diego. So I know that just in recent years, they've allowed us to take more.
Well, I'll be glad to shoot the gun off over the bow and see what happens.
But maybe it should go to 8, and maybe we're missing our negotiating practices.
Exactly. But I also think this too. Janet and I are both on committees, but I don't want it to just be that Janet and I go to these things, because I think they're beneficial to all of the commission to go.
That was gonna
Well,
be my comment, is that because we have 2 people that are on committees, it's almost always gonna end up to those 2 people going, and the rest of us
Yeah,
will
that's
never
not
have
fair.
the option to, yeah.
I will also add at the fall offering, there's actually a new offering that's called Arello Commissioner College, which is actually meant for new commissioners that have come on the commission to learn more about their regulatory duties. And this may be an incentive for some of our new commission members to attend.
It was very good. Did we take number 1?
No, we took
Or
number 2. Well,
Diane, Janet, and I it was
last year.
last year took number 2, I think.
It
There's
was
two-
very, it
there's
was
two different
very
ones.
good, very helpful.
But yeah, I think it's something that all the commissioners can benefit from.
But just as a point on that, because they only offer 1 course a year, so potentially it could take you 3 or 4 years if you couldn't go back-to-back years. The Arello is putting together an online portion to that commissioner college, and hopefully we'll have that up. I'm on that task force to develop education for that. So hopefully we won't have to wait so long to take it.
Well, I'm gonna be like Ms. Hills and say that I think that it's in the best interest of the commissioners to go to the Arello meetings. That we can do our job much more professionally if we have that information.
Training.
I was
Training, and
surprised.
to know what's going on in the other parts of the country.
There are only, the last figure I was given, there are 359,
At the last meeting, they said 348.
48, so, that hold this hat in the states, including Canada and maybe South Africa. So it is a small group.
Gary
So
has
what's
some
the
questions.
pleasure of commission?
Gary has some.
Mr. Bloom?
I'd like to recommend Fontaine Taylor, and you fill in the other blank.
Johnny Horn.
Okay, so Fontaine Taylor, Johnny Horn,
That's to go to-
other commissioners?
Where do I go?
To the next one.
If you end up getting more, if they got that new commissioner thing, I'd be interested in that one
Get
too.
the two people along.
The fall conference is the only conference that offers the Commissioner
And that's
College.
Vancouver.
College. And you have to stay an extra day to do that.
All right, so I have
It's
a,
an all-day class.
a motion on the floor that so far includes suggesting that Ms. Taylor and Mr. Horn be delegates to the Arello Convention or Conference in Vancouver, subject to the state approving and allowing commissioners to travel out of state, out of the 48 contiguous states. Other names,
Bobby Wood?
Bobby Woods, put him on the list.
I can tell you that I'm going, if I have to pay for myself, I'm going because I'm on 2 committees and I've committed to that.
All right, let's put Marcia Franks on the list too, so that's 4. Let's put Janet on there as 5. So, are there others that would like to be included on that list? All right, 2 staff people, 5 commissioners. That's our request to the Department of Commerce and Insurance.
Good luck.
Yeah, good luck. It's not gonna happen.
I don't know that we need to vote on it. I think that's the slate.
Okay,
And if they,
thank you.
if they come back next month and say we can't go to Vancouver, it becomes a moot point. If they come back and say you can send 2, but you can't send 5, then we're gonna have to make some decisions.
All right,
All right.
thank you.
Speaking of Morello, ladies, did you want to report anything about the mid-year meeting? Any, Marcia or Janet, about any 1 or 2 items that kind of stuck out?
2 things that stick out are problems with teams and who's the principal broker and that the teams understand and the principal brokers understand that they're still involved. I mean, not involved, but responsible. And then the other thing was property management. There's lots of people doing property management without licenses. And those 2 things were the 2 hot items that we heard this year. So it seems we're having the same problems as what they are. What's great about it is we can sit around the table and there's people who have done something about it. And here's what they've done about it. That's where the learning comes in. It also, we find out maybe we're doing something that nobody else is doing, and it makes us wonder, why are we doing it then? So I just found it was very beneficial. It was a great meeting. We drove in a car there, and it was good to know Malcolm and Mallory better, and I thought it was a really good meeting, and we benefited a lot from it.
Thank you. Janet?
Well, of course, I'm on the Fair Housing Committee, and one of the things that was discussed in Fair Housing was that we are not going to be the Fair Housing Committee anymore because I guess enough damage has been done in Fair Housing. They don't think we need that anymore. But rather going to a risk management committee so that we deal with not just fair housing issues, but whatever other issues are hot buttons across the board. And then Oklahoma passing the practicing real estate without a license into legislature to make that a felony offense and give them jail time, I thought was smart move. I'm not sure how they got away with it, but it'll be interesting to see what comes down the road from that. One personal thing we found out about Malcolm that I'm very distressed about is that he's a Coke addict. That's Diet Coke. We have to keep him in Diet Coke continuously.
All right, thank you, Janet.
That went on your permanent record right there.
Ms. Kirby, did attorneys get together in secret, and talk about things that you'd like
No,
to share?
not in secret, really. I did have an interesting conversation with the Alabama Council about a potential vacation lodging issue that may become prevalent among all the states, and that is concerning Airbnb. Currently, you just pay like for their advertising space, essentially, so we don't license them. But he was telling me that they are starting, I guess maybe just in some places, to charge a commission for people who rent out their property using Airbnb. So that may be something that it was on our radar at some point.
Oh. Thank you.
John,
Yes, Johnny,
there's one thing I want to,
get close to that microphone for me.
can you hear me now?
No, sir, not yet. You got to talk.
Pull it down some.
How about now?
Perfect.
Anyway, I want to warn us as a board. A lot of times we get where people who do the most go the best places and this type of thing. But if there's training, serious training like the beginners, novice type training, the novice people on the board need to go so that you'll be a better benefit to yourself. You'd also be a better benefit to the board. I was on one before that I had no idea what was going on until I went to the novice training session. And after that, I felt like a useful member. So I think some of the people who go all the time, I think they should go. I don't have no problem there, but I think some way we ought to weed a novice in there so that we can get most of our people through that type of training.
Go ahead. One point to that, Johnny, is that Arillo has also developed a starter's guide, so to speak, so that the states can incorporate that with their training to give you more of an overview. And I think that that's one thing that we can now download and pass on to our commissioners that will be real helpful too.
And
to help get trained.
And my comment was going to be that I know as far as orientation for our positions as commissioners, I think there needs to be more to just come in and give you, here's the policies and procedures, and you need to read it and take an oath. I think there needs to be something done where there is more of an orientation for commissioners coming on, and especially for commissioners who are not realtors. I know this is especially hard for you, Johnny, because you're not a realtor, and sometimes we love that you speak up and say, what are you talking about, you know? I think that's very important, but I think that there needs to be more done in the way, for everybody, even the realtors, we need more orientation, because it takes a couple of months to really sit and listen and figure it out, would be my suggestion for the state.
My point exactly.
Thank you, Johnny. Thank you, Marcia. And with that said, as much training as we can get, we'll still have stuff come in front of us every month we've never anticipated. And so you got to be able to flow. All right, let's move on. Review of financials and statistical reports, Malcolm.
Okay, well, actually, I'm going to do that and my comprehensive executive director's report at the same time. As far as giving you a core update, we are moving on schedule for June the 22nd for automated transfers and applications for licensees and new firms. As far as errors and omissions insurance testing, we have been very successful with the state provider of RICE, in which those feeds are now automated. We have now rolled that out to the other providers as well to begin that process. The next step that we're doing is having the TBI reports as a paperless review, and that's kind of the next step. And then I also wanted to report, especially for those people that are involved with local associations, we had a very good meeting between the Tennessee Association of Realtors and the TREC staff and the IT staff, in which we are going to be able to do feeds for brokerage office list in which you have non-member licensees in the future. This is something that has not been able to happen since they moved over to the core program in October, and we're working towards at least having that probably within the next 30 to 60 days. We've definitely recap the Arello area. The other thing in my report, I also wanted to just give an update at this time under timeshare. One of the things that we learned at the meeting is there's actually a platform on Arello that has a timeshare platform, and what happens is when we get revisions to timeshare or new registrants, the timeshare company actually registers these with all of the jurisdictions that handle timeshare. And Arello actually has a platform that you can actually access where all this documentation is stored in the cloud. And Mallory and myself, as well as Brian McCormick, are analyzing the timeshare registry at this point. We're hoping maybe either in the June or July meeting, we will be coming back to you as far as asking for approval of the TREC participating in the online timeshare process. Staff training, we did do a all-staff training on April the 20th, in which we brought a instructor in on basic rules. I'll remind you that we have at least 4 staff members that are new, I'm included, in which we just had basic rules to be able to help the personnel be able to address questions that come in from the licensees. So that basically is the recap of the report that I wanted to make to you at this point, and then I will get into the financials. As far as the March financials, our total expenditures for March for TREC totaled $75,819. What the cumulative expense for the year is $649,920, with the plus the cost backs of $419,000, which are the activities that we participate in as far as commerce and insurance that we do shared services with. Your revenues fiscal year to date is $1,732,000, and your expenses are $1,248,159, with a net revenue of $483,854. And then I've also outlined in the report and on several pages having to do with your active licensees and inactive, as well as your fingerprint facts as well. So that completes my report.
Questions for Mr. Young?
I would like to, I wasn't sure where we should talk about it or not, but Malcolm and I have talked about, in the past when we have been looking for courses that during the legal reports, when we have something that we're looking for a class for a principal broker who's been penalized, that there wasn't really anything for principal brokers. And I will tell you that an educator, John Giffen, is in the process. He's met with both Ross, and I think he met with Malcolm also, didn't he, Malcolm?
Yes.
And with Steve McDonald from TAR. And he's coming up with basically an 8-hour core class for principal brokers. And not that that's going to be a requirement, but it will give us something other than making somebody have to go back through the broker management 30-hour class that could suffice for principal brokers to go over. And that will be coming in the next month or so before the commissioners for approval. But I just wanted to let you know that that's kind of in the works.
Thank you. Malcolm, where did the fingerprint report? I didn't come up with that, but generally what I care about is, are we still running about 20%
Yes,
match?
we are.
Here it is.
So for every 100 people that apply for a real estate license and have to get fingerprinted, approximately 20 have a match, which means some previous encounter with the law. Is that,
Correct.
Is that how you look at that? So 1 out of 5. Just checking. Thought it was an interesting tidbit. All right, any other questions for Mr. Young?
One last part of my report, and I'd like to yield this part to Mallory, that has to do with the errors and omissions RFP for insurance, because that is to expire at the end of the year.
Yeah, I mean, the only thing I really have to say about it is it's on your iPad. It's a fairly lengthy document. You may have had a chance to look over it. Essentially, we have to put out a request for proposal for bids for errors and omissions insurance. So that is just kind of for y'all to approve. It should look very similar or identical to the last one that we did in 2012, I believe it was, when the last request for proposal was put out. But if you all have any changes that you want in terms of terms of coverage or, anything really, you can propose those and we can get them drafted into the proposal, request for proposal.
I just might note, I did go through the minutes of the last time that you went through review of the RFP for the errors and omissions, and there was I would say, comprehensive discussion having to do with changing of the limits. And the only changes that I proposed in the RFP was having to do with just changing the dates, as far as when the contract expires and things of that nature. That was strictly technical as far as that activity. There was nothing substantive that we have changed on the RFP as far as for your review.
Well, I guess I question, we still have the liability limits of 100,000 and an aggregate annual limit of 300,000. That seems like an awfully small amount.
And even, let's see, I can't remember if this year they changed that you didn't do a rider, or you still do a rider. It still doesn't take it up a
Yeah,
long
you can
ways.
do a
But
rider.
it's only up to like 750, I think.
Uh-huh, it is. That's what this says.
And so this goes out, how many bids do we get on this?
What we'll do is we will send this to all of the current providers.
Okay.
As far as that provide us errors of emission, or that participate in the errors of emissions insurance program, and that actually is a total of 6.
Okay.
Yeah, there's a list of them on one of the pages here.
That's okay.
Yeah.
I just wanted to make sure it was
Yours different.
getting bids.
And they are aware that it is coming up because I have been contacted.
So the proposal is scheduled to be issued, the request for proposal is scheduled to be issued, or noticed to them on June 20th.
But would it not be a good idea that we ask for better, more coverage for our, like 200,000 or 300,000? I know I just went through a lawsuit, and $100,000 won't get you far.
I mean, you can, if the commission wants to request that, we can certainly put it in the request for proposal. Keep in mind that, I would assume that would probably raise your premium costs, but.
Yeah, I think it
Yeah.
should, but, it's not gonna raise it where somebody's gonna have to come out of pocket $100,000. So I think we should ask for maybe different benchmarks, maybe a 300,000 level or 500,000 level or something like that. What would it be at this?
Okay.
And then bring that back to us
Right,
to
bring it back.
decide,
Mhm.
is that too much to ask? licensees.
I guess the question I would ask of Mallory, timing-wise, timeframe of the commissioners to finalize with our deadline date of June the 20th. So we could bring this back on June the 1st.
Yes, I think so. I may have to check at the lunch break because I know this has to go to the central procurement office after it's been approved. And I don't know what they have to do to it there before it's put out for notice, so I don't know how much time they need. But I can try to check on that over lunch. We have another attorney in the department that does the contract stuff, so I don't know a lot of specifics about the process. But I can certainly take back whatever requests you have and see what we can do with it.
Well, I certainly feel like the minimum should be 250,000. I mean, I'm not sure it shouldn't be 250 with a 500 aggregate, but 100 is just, I mean, in Franklin, if you get sued, they just gonna laugh at $100,000.
So I think Ms. Grisham gave us a report, and I don't know if we asked the question, but I don't recall that there are a lot of claims over this minimum amount. I think the claim history would drive me as to whether.
Right, we need to know that too.
So
Right.
if we could find that information, that would be
I
helpful.
don't still
And if
have
we
it.
just got that, we could vote on that in the June meeting
Yep.
then?
Yep. Further discussion on that topic? Okay, Malcolm, anything else from your point of view?
That concludes my report.
So I need to know exactly what you all want me to ask about, so I know what information to come back with
I'd like
in
to
June.
see, this is what 250,000 would cost, this is what
Okay.
300,000 would cost,
Okay.
and this is what 500,000 would cost.
I
And
think we might need
okay.
to start lower. We're at 100. Let's see what 150 is and 200, because I think what
Okay.
Commissioner Grease was saying, we're not having these massive claims, but maybe this is an opportunity just to bump it up a little bit.
Yeah,
And
and
she
we need that
provided
information
us-
too, it's what are the claims?
Does that make sense?
She provided us
We're
with
asking
a
for-
report, but I don't know.
we're
So
asking-
you would
Don't
want
have
the,
it.
the people that are putting in bids to provide what those costs would be at those levels?
Yes.
Okay.
Well, you have to be a little bit careful because they're bidding, right? So they're not gonna show you what their bid is gonna be until they respond to the request for proposal, I wouldn't think.
Right.
But maybe another state somewhere, maybe your Rello guys have somebody that's got a higher limit in another state, and get some sense of what that premium is.
Well, I was pretty amazed at how many states do not require E&O insurance.
Right. Most of them, majority of them.
Yeah, I think we're one of 7 that actually require E&O insurance.
It's maybe a little more than that, but certainly less.
It was very
It's a
minimal.
low number.
All right, we haven't helped you much, have we yet, Mallory, or do you?
So you want to know if we can add a request for different levels of coverage. So 150, 250, 500, are there any other numbers you want to put out
Well,
there?
what about this? What if we had the ability of a choice? What if she wanted 500 and I wanted 150?
Just
I mean,
to-
is
for
there no way to have a
riders.
choice?
Yeah.
I think
for
what you'd
riders.
have to do is have a base and then riders of the
Yeah,
additional
that's what we
amounts.
have
What you
right
have.
now.
But I do feel like the 100 is too low in today's world.
Okay.
And knowing what legal fees are, truly are. Too bad our lawyer isn't here.
Okay, I will take that, I will see if I can find out at lunch if that's something we have to vote on to be requested in the proposal today, or if we can wait until next month.
And there may be an issue with the procurement department, or maybe statutorily, there's some issue as well, I don't know, but
Yeah.
thanks for, I'm glad you got all the clear direction you needed from us. All right, Mallory, we've handled the reinstatement rule amendment, right?
We have.
That's off the table. So let me talk to the audience just for a second. We have a fairly long set piece of our session which is devoted to hearing complaints. People file complaints against licensees all the time. Sometimes they have merit, sometimes they don't. The complaints are filed with the Real Estate Commission and directed to the Law Department, and the Law Department endeavors to get all the facts about the complaint. First, by analyzing the complaint. Second, going to the respondent or the person who's been complained against and try to get their side of the story. And when they think they have all the information they need to report back to this commission, they write a narrative that is anonymous in the sense that we will have no idea who they're talking about, what part of the state they live in. It's designed for us simply to hear the pertinent issues and then make a decision. And to help us make a decision, the law department makes a recommendation on each case. And this commission can accept the law department's recommendation, we can modify it, we can reject it. So we're about to get into that process today. And we're going to do it in two parts. We're going to do a little bit before lunch, and then after lunch, we're going to make an effort to try to put the complaints up on the board. Hopefully you can read them. We don't know if you can or cannot, but you'll get to see it from two different perspectives. All right? Any other comments before we get going? All right, Ms. Kirby.
Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. 2015-02-19231. The following is presented at the March 2016 meeting.
Now, let's talk for just a second. Can you hear Ms. Kirby okay or not? Okay, good. Okay, Valerie, thanks.
Okay. This one, I don't think it's necessary to reread the entry. If I could skip to the prior decision and the new information.
Please do.
Okay. The decision at the last meeting, the March meeting, was a consent order in the amount of $1,000 for failure to respond in violation of TCA section 6213, 313A2, and then B14 to tie in the civil penalty range. The new information is that the respondent had actually submitted a response on January 7th, but it was not referred up to the legal department with the file. So my recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner Wood, that this complaint be dismissed per council's recommendation. Is there discussion?
How often does that happen?
Fairly often, except that usually when we ask for it, we double check with them to make sure that there's nothing that was missing from the file, and that still didn't get referred up to us this time. So that's why it ended up back on the report.
All right, the second complaint is an old complaint.
We didn't vote on
that.
Thank you. And before we get to that, I think we should vote on the first one.
Oh.
All right, you've heard the motion. It's to dismiss the complaint. Let's vote. Those in favor vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number two is an old complaint, as I was saying.
Yes.
And the original recommendation from legal was to monitor litigation that was in progress related to this case. And I assume, Ms. Kirby, that there's new information at this point.
There is new information. Would you like to hear the whole thing?
No, I just want the new information.
Okay. You may ask for the whole thing after I read the new information.
Oh, we may. We'll see.
2015-01-4631. The new information is that respondent's spouse, and the company who was the purchaser in the case were voluntarily dismissed from the civil lawsuit on November 30th, 2015, and the complainant submitted a letter to TREC staff requesting to withdraw their complaint. In regard to the substance of the lawsuit, no violations of the Tennessee Broker Act are apparent. However, while it may be true that respondent was not representing respondent's spouse's company in the transaction, and that respondent was acting purely in a personal capacity, it is concerning to legal counsel that respondent sent complainant the purchase and sale agreement from respondent's firm email with respondent's licensee signature at the bottom, and that the closing took place at the respondent's firm. In addition, it does not appear that the buyer, a corporation, was represented by a licensee if respondent was not acting in a licensee capacity. And my recommendation is to discuss.
Okay, commissioners, do you want to go back and review this complaint?
Yes, please.
I think we have to.
All right, Ms. Kirby, thank you for the offer. Let's do it.
Okay. The matter was originally presented in September of 2015. A complaint was filed against respondent principal broker by a seller stating that respondent failed to pay off complainant's mortgage as agreed to in the sale of complainant's property. Complainant states that complainant has no knowledge of agreeing to an assumption of the loan or entering into an agreement with the name of the person who is shown as the purchaser on the property. Complainant states that complainant did not meet the person who signed as purchaser of the property until April 20th, 2015, when the complainant signed the closing documents. Complainant suspects complainant's name was scanned into the document, the assumption line was checked on the document, and respondent's name was replaced with the other name. Complainant further states that a quitclaim deed to change the ownership of the property was entered at the Register of Deeds. Complainant further states that respondent did not forward a copy of the closing documents as promised. Complainant states that complainant was told to provide the password for the online mortgage so respondent could obtain the payoff that day. Complainant states that when complainant attempted to access the account later, the password and address on the account had been changed, there had been no payoff, and a mail-in payment for May 2015 had been received. Complainant states that respondent took out an insurance policy in complainant's name. Complainant alleges that respondent made false promises, made willful misrepresentations, and participated in improper, fraudulent, and dishonest dealings. The respondent denies the allegations, stating that there have been no altered documents in the transaction. Respondent disclosed to complainant that respondent was a broker and was not representing complainant in this transaction. Respondent met with complainant explaining that respondent and spouse, through the spouse's company, were interested in purchasing the property as an investment, not as an agent. Respondent did not receive a commission or referral fee from the sale and did not represent the complainant. Respondent states that respondent did not prepare any of the transaction documents, did not correspond with the title company, and did not review the HUD prior to closing, and did not attend the closing. Respondent states that respondent met with complainant on March 24th to present two offers to purchase. The first offer was to purchase the property for $104,000, which included buyer financing, and the second offer was for $118,000, in which the buyers would leave the existing mortgage in place. With the second offer, respondent and spouse would not be assuming a loan or paying off the loan, stating the loan would be in complainant's name, and respondent and spouse's company would make the monthly mortgage payments. In addition, complainant would receive $300 a month for 47 months. Respondent states that complainant chose the second offer in order to use the extra money to pay off credit card debt. Respondent states that respondent explained that if complainant wanted to purchase another property and obtain financing, the loan would still show up, but complainant was not concerned, stating complainant had no plans to purchase another property. Respondent states that respondent reviewed the purchase and sale agreement with complainant, which was between complainant and respondent's spouse's company. Respondent state that complainant elected to receive a copy by email. Respondent states that respondent's spouse reviewed and signed the documents, and respondent emailed the fully executed purchase and sale agreement to complainant the next day, March 25th, 2015. Respondent states that on April 20th, complainant met with respondent's spouse and the title company's closing agent to close. Respondent was not present, but states that respondent has knowledge that the complainant signed an addendum stating that the complainant understood that the buyer was not assuming the payoff or paying off the loan. Respondent states the insurance company admitted to making a mistake by sending a bill to complainant instead of the lender. Respondent denies representing either party in the transaction, denies forging any documents or signing complainant's name. Respondent states that respondent treated complainant with the highest level of professionalism and honesty, explaining everything entirely. Office of Legal Counsel followed up with respondent to obtain additional information in the transaction file. Respondent states that complainant was aware that respondent was a broker because complainant referred a family member to respondent. Respondent states that there is currently civil litigation against respondent's spouse's company, and the title company. Respondent states that the title company made a mistake on the settlement statement by including the words payoff instead of stating that the company was buying the property subject to the existing mortgage. Respondent further states that complainant and respondent's spouse signed a promissory note, and complainant retains the original executed promissory note. Complainant further states that respondent further states that the company has been paying the $300 a month, which complainant has been accepting. The standard agreement to purchase real estate is dated March 24th, 2015, in which respondent's spouse's company is listed as the purchaser and the complainant as the seller. It states that the purchase price is $118,000, payable in the amount of $300 for 47 months, and that the purchaser will be taking over the payments. It appears that respondent's spouse signed his own name at the bottom. It appears that this contract was emailed to complainant by respondent on 3/25/15. There is an acknowledgement agreement and an addendum dated April 20th, 2015, stating in relevant part that the complainant acknowledges, understands, and agrees that the existing loan will not be transferred to the buyer, and the buyer has no intention of assuming or paying off the subject loan. Also included is a promissory note in which the purchaser agrees to pay complainant $15,900 in monthly payments of $300, but is not executed. The settlement statement is dated 4/20/15 with complainant's family land trust listed as borrower and complainant as seller. There are multiple trust documents in which complainant grants the deed to the complainant's family's land trust with a third party acting as trustee. Complainant also quitclaimed the property to the purchaser. There are checks and bank documents indicating mortgage payments have been made by the purchasing company, as well as $300 checks to complainant that complainant has cashed. Further, it appears that complainant has filed a lawsuit against respondent's spouse, purchaser, and the title company. At this time, only the title company has been dismissed from the suit. It is likely that further information will be uncovered through the course of litigation, which will be pertinent to the Commission's determination regarding this matter. And the new information is what I had previously read.
Okay, would you tell us again your concern?
My concern is that well, there's two things really. The respondent says that the respondent was not acting as an agent in the transaction, that it was purely a personal transaction. I don't know if the commission thinks this is a problem. I wanted to bring it up to your attention that even though the respondent says that, the purchase and sale agreement was emailed to the seller from the respondent's firm, real estate firm email, with the the real estate signature at the bottom, and the real estate closing took place at the real estate firm. Also, the buyer is a corporation, which is not a licensed real estate firm, and so if the respondent is claiming that the respondent was not representing the corporation in the transaction, then the corporation to me is acting unlicensed without a licensed broker representing them.
But it's fine for its own account, right?
But this is a corporation, so that the owner exception doesn't apply to corporations unless it falls in the corporation exception, which is only if it is not the vocation of the corporation to be doing real estate, which this sounds like it's an investment company which does buy and sell real estate.
Ms. Hills?
So, do I have this clear, that the seller was to keep their loan in their name from a bank, I assume, lender,
Mm-hmm.
from a lender, and that the licensees then were to have the deed in their name, correct? It was deeded quitclaim to the licensee's name. So where's the lender fall into this, that they think they can do
Not a
that?
lender, yeah.
And the promissory note was not even executed.
I mean, there's no lender I know that would be
Agree to
happy
that.
to that.
There's no lender I know that it would even be legal to do that.
Well, owner financing it might be.
Owner financing, but this.
It's
Yeah,
different
that's what
from
it
having a
sounds. That's what
mortgage.
it sounds like to me is owner financing.
Owner finance.
But you owner finance when you already have a lien. I don't see how anybody.
I think the buyer's just basically paying the existing note and then giving some additional monthly payment to the seller.
It's a land.
So, I mean, they're not taking over any of the indebtedness.
Right.
I mean, the seller is still all at risk. I mean, it's,
But the
But they
deed,
quitclaimed the deed, yeah.
name is now in that new buyer that.
yeah. I mean, it's not a clean way to do business, but they still did the business. It looks like everybody agreed to it. I want to go back to this question. So, are you saying because I would consider this like a
Bank fraud.
for sale by owner.
Right.
I mean, that both sides were represented, but were you saying because the buyer is a corporation, they have to have representation?
Correct.
I don't want to go there.
So the corporation itself can be exempt from licensure, but the person representing the corporation cannot, because they're a separate legal entity from the corporation and the person representing the corporation. Whereas if you have like a partnership where there's no legal separation between the partners and the company, then the company and the people representing the company would both fall under the owner exemption and would not need a license. But because the corporation is a separate entity from the person representing the corporation, even though the corporation could be exempt from licensure, the person representing the corporation is not exempt from licensure. Unless they fall under the very narrow exception carved out for corporations, which it really doesn't seem like that would apply here.
But I don't think anybody was representing anybody in this transaction.
And is that what the complaint
Well,
is?
somebody has to represent the corporation in the transaction. The spouse of the licensee acted on behalf of the corporation, and that person does not have a license.
Okay. So you're saying an individual who's not licensed can just go buy something without an agent, without representation? But you're saying if the buyer is a corporation, they have to have representation?
Yes,
I don't know if I agree with that.
unless they fall under the exception, the narrow exception.
I don't
That was
know.
the Attorney General's opinion. I know when I first came on the commission, that was so shocking to me because, my family, we are realtors, developers, and have several LLCs, and I was not aware of that. And so I asked, where did you get this? You're gonna have to show me this. And they, during lunch, brought, the Attorney General's opinion to me, and it specifically says that. It was shocking to me too, but that was the Attorney General's
So, because
opinion.
Walgreens is not in the real estate business, they can't go buy their own property without an agent.
Right.
Well, now, they potentially could fall under the exception because Walgreens is not in the business of buying and selling real estate.
Okay.
So they could potentially fall under the exception where one of their employees could be purchasing a property for the company if that's what they needed to do. I think the intention of the statute is so that people don't form corporations and LLCs with the sole purpose of buying and flipping properties and selling them and then not getting a license.
And that's what we were talking about under the 2017 proposed legislation.
Right.
That she was saying that the LLC, that needs to be codified into the law, because people are, I've had a lawyer look at it, and they didn't interpret it the way the Attorney General looked at it. But, here I am, a commissioner, I have to pretty much go by the Attorney General's opinion on it.
And the narrow exception for corporations also, and this was clarified by the Attorney General, says that even if, so in order to fall under the exception, the person who's doing the buying and selling of properties for the corporation, one, it cannot be their vocation to be buying and selling properties or leasing or whatever, any real estate transaction. They also cannot receive any payment that directly relates to the sale of real estate, and that includes dividends being paid out. It doesn't necessarily have to be a commission. It could be being paid out dividends from the corporation because the corporation has made money on the sale of the transaction. And that's not me deciding that. That's what the Attorney General said. So.
Okay, to try to move this along. I'm going to say, since everybody in this situation looks like to me they've kind of kissed and made up, and so I'm going to make the motion to dismiss.
Second.
We have a motion by Commissioner Wood, second by Commissioner Franks, that this complaint be dismissed. Now, discussion on the motion. Mr. Bloom.
Well, yes. Mallory, do you know if the lender was aware of this transaction?
I believe they were, but I don't know that for certain.
So they nodded to the $300 over and above their payment to be made?
Well, I don't know for sure, but I would assume that that's all in the settlements, the closing statements, all of that agreement, but,
And so the last purchaser assumed a loan without being approved?
well, no, the loan is still in the seller's name.
I know.
They didn't
but
assume the loan. They're just making the payments on the loan, but they did not assume the
They're making the payments on the
loan.
loan, and they're making $300 to the person they bought it from.
Mm-hmm.
So that's illegal.
I don't know that doesn't fall under the Broker Act, so I don't know about that part. But we don't, if that's illegal because of federal, lending laws, then that's another issue, but.
And to complicate it, it's the corporation that's making the payment, not the licensee. All right, further discussion. You've heard the motion offered by Commissioner Wood, second by Ms. Franks, that this complaint be dismissed. Let's vote. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no.
No.
All right, the chair is going to rule, unless somebody else wants to speak out, yes or no,
Oh,
that the
there are
motion.
three people.
I think the thing is, I haven't made up my mind yet because I don't have enough in front of me here.
Maybe
Because-
this is one we should have a commissioner take and review.
See, I like that concept generally, but we've had a court handle this. I mean, the court has come
Well-
along and voluntarily dismissed everything against.
Well, the court
Everything.
didn't, they just voluntarily
They
dismissed
just
it. They said
withdrew
we kissed and made up.
Yeah, they withdrew it.
You
Well,
volunteer?
well, that being the case, I mean, that court has heard a lot more than we would ever get from a commissioner studying this file.
Make a motion.
We've
They've
still-
also withdrawn the complaint.
Well, let's do this just for the record. I'm going to rule that the motion passed. Now, somebody can challenge that or ask to vote again, and I'm happy with that, but I didn't hear but one no when the vote was called for. So is there a desire to roll call the vote? I'll be glad to accommodate that.
Yes.
Okay. So, Mr. Young, if you're, we'll roll call the 8 commissioners here. If you're in favor of Mr. Wood's motion to dismiss this case, you'll vote yes. If you're opposed to it, please vote no.
All right, roll call. Chairman Grease,
Yes.
DeChera,
No.
Bloom,
Yes.
Hills,
Yes.
Franks,
Yes.
Wood,
Yes.
Taylor,
Yes.
Horn,
Yes.
and I have 7 yeses, 1 no.
Motion passes on a final vote of 7 ayes and 1 no. We will reconvene exactly at 1 o'clock here. Make sure you guys initial on the way out and sign. I guess you have to sign when you come back in, but do what you're supposed to.
Initial.
I think.
Do what you're told.
Good. Brooke Wagner has got an announcement to make. Brooke, can you yell from there, or do you want to come up to the microphone?
Anybody whose name is highlighted in yellow and have not come and seen me, you need to do so more than likely on our next break or when you get ready to leave, because that is how you will get reinstated. If you do not see me and you don't fill out your paperwork, you very likely will be able to get reinstated very quickly. So, thank you.
All right, and hopefully everybody either signed in or initialed as they came back in. If not, please do that quickly. All right, Ms. Kirby, are you ready to go?
I'm ready.
Item number 3.
Do we want to talk about the proposal first or later?
Let's go ahead and talk about it. That's a great idea.
Want to talk about it? Okay. So I spoke to the Office of Legal Counsel about the request for proposal for the different coverage amounts. He told me that we can go ahead and add that to the request for proposal, give it and give it to the attorney that does that, and as long as there's no problem, as long as they don't see any problem with it, we can just go forward with it. I don't think it doesn't need to necessarily come back to this commission unless they see a problem with it. So, if y'all are okay with it, I'll take back that you would like to add to the request for proposal costs for $150,000 worth of coverage, $250,000 worth of coverage, and $500,000 worth of coverage.
Excellent.
So what do you think that means? That's going to be added into the RFP, or is it just for our information purposes?
That'll be added into the RFP is that was my understanding of what y'all are asking. Now, if that's not correct, you can just let me know. But yeah, so that'll be added to the RFP unless the council that does contracts, if she sees a problem with it, she'll let me know and I can bring that back to the commission. But if she doesn't see a problem with it, it'll just get added to the RFP and it'll proceed from there.
So really, my own personal sense is I'd like to hear from the current provider as to the necessity of doing this. So, and with that said, I did put in a call to Ms. Grisham. I haven't heard back from her.
Okay.
So could we just delay this a little bit then? If we don't hear
Sure.
by the end of the session, we'll go ahead. But I'd like to know what the provider has to say about this.
Because we'd had a report, she had given us a report, and I don't have it with me, I may still have it, but I know what you're saying as to, is it warranted? What she had it broken down.
I don't want to, just personally, I don't want to take 26,000 licenses and add a fee to it that's not needed.
Mm-hmm. Yeah.
That's what I'm.
Was the idea that the extra coverage would be a higher amount for everybody, or that people would have choices about how much coverage they wanted?
My idea was that we would have choices.
Fontaine, would you pull that microphone closer, please?
My idea is that we would have choices.
But keep the minimum at 100,000.
Right, keep the minimum at whatever, 100, I guess. There's not gonna be much difference between 100 and 150. But if someone wants a higher coverage, that they could get it at such and such a price. That would
And
be an option.
I'm sure they'll say there's riders that already in place that you can get. But I think most people don't know about them. They
Right.
just,
Well, they're
Pay the
on the
state E&O.
statement. They're on the statement, and, but they're not high. I think the limit on the rider is $750.
So just to be clear, the intent is to keep the minimum, but to increase the number of different price points to buy additional coverage. Is that what we're talking about?
That's what I understand from you
Okay.
all.
That's what-
That
So
was-
for the proposal, you just want them to give the cost amounts for those different levels of coverage.
I think a lot of people, the broker gets certainly the agent pays for it, but the broker gets the thing, and they really don't know what they have one way or another.
Mm-hmm.
And I don't think that they know that they have options, and some people, I know if I had the option of having a higher amount, I would most probably take it. Especially if you were a broker of the company. I would certainly have.
and not only that, it doesn't include new home construction. It doesn't include if you are a partner in the new home construction or any personal properties.
So do we want to wait until if you hear from
If you
Cindy
don't
or?
mind, let me just see if
Sure.
if Cindy calls back.
Okay.
If she does, we'll see what she has to say. But as long as we keep the minimum is fixed, I don't have a problem with it myself. Okay, item number 3 is one we've discussed previously. Can we go to the end, your new recommendation, and see if we have to work backwards or not?
Yes, sorry.
And if you'd like to give us just a synopsis of what the case is about, rather than reading it all, that'd be helpful, if that's possible.
Okay, this one, let me read the case number. It's 2015-02-19271. This is one where the affiliate broker had switched firms, and in doing so, the complainant, who is the previous principal broker, is claiming that this respondent took listings from that firm, and that this person changed expiration dates of listings in the MLS and took paperwork from the files that showed when the listings were expired and things like that. That's the general nature of the complaint. There were several different properties listed in the complaint. Your original decision was for a consent order of $6,000 for improper, fraudulent, or dishonest dealing, and the rule about licensees not being able to take property listings unless authorized by the principal broker, plus some education requirements on top of that. So the new information is that that was only, the consent order that was authorized previously was only for three of the properties mentioned in the complaint. The new information is that the respondent submitted a listing agreement for additional property 4 with an expiration date of 8/5/15. Respondent states it was originally entered incorrectly by administrative staff in the MLS. To me, that made sense because that would make it a 6-month agreement, which started on February 2nd. We didn't have that listing agreement before that showed that expiration date. Let's see. In regard to the initial property, the respondent states that there was no buyer's representation agreement with the customer. Respondent states respondent showed the property to a customer on August 8th, the same day respondent submitted the TREC 1 form, and the customer decided to make an offer on the property. Respondent states that since respondent was in the middle of transferring firms, respondent's new principal broker wrote the offer, and the listing agency mistakenly put respondent as a selling agent on the MLS, but corrected it later. Legal counsel requested the purchase and sale agreement and confirmation of agency status form from respondent to verify that the principal broker was the agent listed on the forms, but respondent did not. Not respondent, but respondent states that the principal broker has the paperwork. The principal broker would not provide these documents when requested by legal counsel. So my recommendation is a consent order for $500 each for violation of TCA section 6213 312B20 improper dealing for the initial property, and property 3, which I did not provide any new information for property 3. And that was because before we had cited, and this was, I think, probably my mistake, cited taking the listing agreement as with the initial property, but there was no listing agreement. This was a buyer. This wasn't a seller. So, reducing that one, and then $1,000, which is what you all authorized for the additional property 3 for taking that listing, and then I eliminated the violation of property 4 since she provided that listing agreement that said the date that was then entered into the MLS. So the total of $2,000. And if you all want to add the education back from the original decision, that would be fine too.
So I have a couple questions now. One is just a general question. So we make a decision, you take that decision to the licensee and say, here's what the commission is willing to offer you in exchange for this to go away.
Right.
When you made that offer to this licensee, then did he provide additional information?
Yes, this licensee called me and provided some additional information. There wasn't additional information for every part of the complaints, so that's why some of it's untouched here. But there were a couple of things I thought was new information that.
So why wouldn't he or she provided that information at your first request?
That is a valid question. Always when people do this, a lot of times I tell them that should have been included in your original response. However, if I think it's something that would potentially change the commission's decision, I feel like it should still be presented, because otherwise they may, if they feel they have other information that would change the decision, they may choose to go forward with a hearing, and then you're going to spend a whole day on a hearing instead of 5 minutes on representing the complaint.
Personally, I get the sense that some of these licensees don't take the initial request seriously. They just kind of blow it off. Then we make a decision, make an offer that's significant, financial penalty perhaps if they accept it, and then they decide to get serious about the request.
I think sometimes that's the case, but sometimes I think that once they know what the commission sees as the violations, and I think sometimes they're unsure about what violations they even committed, and then once they see what the commission has authorized, then they're like, well, I have something else to show you that that's not the case. So I think sometimes that can be true, but I don't think that's always true.
But you always cite it when you send them the information of what they have violated.
Not when they get the original complaint, because the legal department doesn't send out the complaints, that's staff, and we just don't want staff trying to determine what they potentially violated. So they just get the complaint in whatever form the complainant puts it in, and sometimes it's clear what the alleged violation is, and sometimes it's not as clear. So I think that's sometimes why this comes up again.
Okay, my second question. So your recommendation is to take it from $6,000 civil penalty to $2,000.
Yes.
So there's you see $4,000 worth of new information.
Yes.
And would you tell me again what new information that is? Not
Sure.
having the buyer's agreement, is that it?
So for the initial property, we had cited, and I cited, and like I said, I think this is my mistake. The initial property, I had cited that when the licensee terminates affiliation with a firm, he shall neither take nor use a property listing secured through the firm. Well, there was no property listing with that firm because it wasn't a seller's thing. It was a buyer's thing, but they didn't even have a buyer's representation agreement with the party. It was merely just a customer. Okay. So that's why I don't think that applied at all, and that's my fault.
Is that $2,000, the $4,000?
That's $1,000.
Okay.
Let's see. The other 2,000 was for property 4. So we had the improper dealing and the listing agreement violation for property 4, but she submitted the listing agreement that showed the date that was on the MLS, which the complainant claims was changed to that date, but originally the complainant said the listing agreement was for until August 15th. And then alleging that the respondent changed it to August 5th so that the respondent could then take the listing as expired. But the respondent sent us the listing agreement that said it actually did expire on August 5th. So that's why I was saying suggesting to get rid of both of those violations. So that's 2,000, so we're up to 3,000. Then, because the initial property, let's see, so I had said 500 each for the improper dealing for both property 3 and the initial property, just because I think there was a lot of confusion between the respondent and the respondent's broker about how it should be handled, and I don't think it was clear that the respondent actually acted on behalf of this customer. She claims it was the broker that did it because she knew she wasn't yet affiliated with that firm. So that's why I said 500 for both of those. Now, you can always bump that up to 5,000 each for a total of 3,000 if you prefer.
But you're saying that there was a buyer, she had a buyer, and she knew she was leaving the company, but the paperwork was not done and signed and everything, and so her new broker said, I'll just be the agent on it, and then once you get here, it'll close, and then I'll give you the commission on it. Is that correct?
Well, she didn't say anything about the commission. Actually,
Well, I mean, that would be the whole reason for doing it, though,
well,
right?
actually, the commission was paid to the original,
Oh,
the
really?
first principal broker, even though the principal broker, the new principal broker, said he didn't really think that was owed to that company because the offer wasn't even made till after the girl left the firm, and there was no buyer's representation agreement between her old firm and the buyer, because they didn't have a contract yet. She was just it was just a customer. So, and then, but he said just to avoid any problems, he went ahead and paid the previous broker the commission. So that's why I didn't recommend the max, because I didn't think it was, but also the broker would not provide the confirmation of agency status and the purchase and sale agreement with the broker's name on it instead of the respondent's name, which is why I left the violation at all, because the principal broker we had a complaint open against the principal broker. Principal broker has executed the consent order, and just didn't want to. Yeah. So.
All right, the chair's ready to entertain a motion.
I'll move to accept council's recommendation.
You gonna add the education or no?
And let's see, okay, let's add some education.
That was original.
That was in the original, if you
So
want to
it's
just add the same.
Okay, whatever the original education was.
It was 8 hours, 4 hours of professional responsibility, and 4 hours in ethics.
Okay, that's good.
I'll second.
Okay, a
For
motion
a
by
meeting.
Commissioner Frank, second by Commissioner DeChara, that the original decision of this commission be confirmed with the exception that the civil penalty be reduced from $6,000 to $2,000. Is there discussion on the motion? Ms. Taylor?
I would like very much, when an agent signs off with a broker, and before he can get his license and sell, he has to not only sign the paperwork, but it has to go through TREC, correct?
Correct.
So, to clarify your thoughts, to clarify my decision, making a decision, was this during that time period right there that this one offer you're talking about was done?
So the respondent submitted the TREC 1 form on August the 8th, that evening. That morning of August the 8th, the respondent showed the house to the customer, that there was no buyer's representation agreement, it was just a customer, showed the house to the customer. What I understand from the response is that later that day, after they saw the house, they wanted to make an offer. And the respondent said, well, I mean, I'm like technically still affiliated with my current firm, but I'm switching firms. And so her broker that she was switching to was like, well, then I'll just write the offer and do the paperwork until it gets approved by TREC.
So the broker has already been, we've already done something with the broker, correct?
Yes.
Broker number one,
The principal,
the
Principal
new
broker
the
number
new
one.
principal
broker.
broker.
the new principal broker,
But-
okay.
But the broker who he or she was affiliated with that morning did get paid?
Yes.
Okay.
Which that was a broker-to-broker agreement that they decided, obviously, if the second broker said, I don't want any problem, you get the commission, correct?
Mm-hmm.
Okay, further discussion. You've heard the motion. If it passes, a consent order with a civil penalty of $2,000 will be offered to the licensee along with the requirement to either come to one of these meetings or complete some education.
I would like to make a friendly amendment to change the 2,000 to 3,000.
Okay, now, I'm happy and willing to entertain that amendment, but you're going to have to tell me where to add the extra 1,000. A lot of likes for it to be
On
specific.
that piece, the piece of property that the new broker wrote the offer on. I think, let me go back and see where that was exactly.
And here's the thing I want to just make a comment on for brokers. If you will do the transfers online, it is immediate. And you print that receipt out and they are transferred. You don't have to have all this delay and this problem with, I left today and I've got to wait 3 weeks.
Well, I'm gonna have to go back then in my thought process, because that would be on the broker, it wouldn't be on the agent.
Right.
Right, so I guess we'll have to leave it like it is.
All right, other comments? You've heard the motion, $2,000 civil penalty plus education or attendance at a meeting. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 4.
20150223291. Complainant states that another agent was the original selling broker and prepared the sales contract and supporting documents, and that after closing, respondent, who is a broker owner, whited out the other agent's name and recorded respondent's name as the selling broker. The seller in the transaction was a member-managed LLC for which respondent was a member. The LLC was the builder-developer for the property. The complainant states respondent had a duty to disclose pertinent information regardless if it was sold with a warranty or a resale. Complainant buyer states that sellers provided complainant with a residential condition exemption notification, but that the property was not new construction pursuant to the intent of the law. Complainant states that in 2007, the lot was graded empty and free of any construction efforts. In 2008, the brick foundation was completed. In 2013, the foundation remained the only completed construction phase. Complainant states that the foundation was exposed to the environmental elements from 2008 to 2013, causing deterioration which can affect the stability of the home. Complainant states that prior to 2011, residents complained to the county officials regarding the unsightly appearance of the lot, stating there were weeds 6 feet tall and growing in the exposed foundation. Complainant states that building resumed in 2014, and when the brick siding was being reconstructed, the bricks used on the foundation could not be procured, so the existing brick was acid washed in an attempt to conceal the fact that the materials did not match the foundation, and the foundation was sitting for approximately 5+ years. Complainant states that this renders the property not new construction under the intent of the law. Complainant states that respondent knowingly and willingly withheld pertinent facts that were required to be disclosed under the law. Complainant states complainant will suffer incalculable financial losses when selling the property, since they are required to disclose the facts regarding the questionable stability of the foundation. Complainant states that complainant suffers stress created by not knowing the stability of the exposed foundation, coupled with the fact that the hardwood floor has several indented or low spots, apparently caused by the subflooring giving way to some type of stress regarding the foundation and related joists. Complainant states large areas of the hardwood became unglued from the subfloor and indents when stepped on, indicating some part of the structure has shifted as wood from the real gabled end of the house has wood protruding through the brick. Respondent states that respondent met complainant on the property in mid-August 2014 and disclosed that respondent was an agent with the listing agent's firm as well as a developer of the subdivision. Respondent states that a personality conflict had developed between complainants and their agents, and complainants requested to deal with respondent directly as the chief manager of the LLC. Respondent states respondent fully disclosed that respondent was a real estate agent, which complainant acknowledges in their complaint. Respondent states that complainant liked the property and had driven through many times and was glad to see the developer finishing the property. Respondent states that the builder provided a 1-year written warranty at closing. Respondent states that the weeds were treated regularly and there were 3 to 4 times during the 7-year period where the weeds grew to maybe 4 feet, which could have been avoided if the HOA had notified respondent. Respondent states that there were no defects and complainant declined a home inspection. Respondent states complainant made numerous trips to the property prior to closing and made no mention of the bricks. Respondent states that the bricks are the same, but the batch lot may be slightly different. Respondent states that Tennessee law states construction is new as long as the title has not changed hands. Respondent states that the foundation was treated with water repellent before construction ceased and after the foundation was laid and that the bricks were inspected prior to the restart of construction and found to be in good condition. Respondent states that any and all items in need of attention per the builder's warranty are or have been addressed. Respondent states complainant has not mentioned any item in this complaint except the floors until the complaint was filed. Respondent submitted a confirmation of agency form signed by all parties indicating the other agent in respondent's firm was the designated agent for the seller, with respondent signing as chief manager of the seller LLC. The purchase and sale agreement also has the other agent listed as the listing licensee and is signed by the complainant and respondent representing the seller. The condition exemption notification form with the box checked for the first sale of a dwelling was signed by both parties, and a copy of the builder's warranty was also provided. Respondent provided the Get a Home Inspection document, which is signed by complainants and shows they chose not to have a home inspection. A letter voiding the certificate of occupancy and listing several repairs needed was provided, but is dated October 28, 2015, 2 days shy of the expiration of the builder's warranty. The recommendation is to dismiss.
Move to dismiss.
Second.
We have a motion by Commissioner Frank, seconded by Commissioner Chara, that council's recommendation be adopted and this complaint be dismissed. Is there discussion? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 5.
2015-0224441. A complaint was filed against respondent firm by the owner of the property. Complainant hired respondent in October of 2012 to manage respondent's property. Complainant alleges that in the first lease, complainant had to constantly address mistakes and errors made by respondent, but complainant decided to keep working with respondent. Complainant states that the first tenants caused damage which cost complainants $826 in repairs. Complainant states that the second lease included one individual as lessor for a 1-year lease agreement which did not allow animals. Complainant states that after multiple mistakes made by respondent, complainant fired respondent for property management at the end of the second lease. Complainant states that the tenant on the second lease only resided on the property for 4 months, and the tenant's son, girlfriend, child, and dog resided on the property for the remainder of the lease term. Complainant states that respondent claimed to have no knowledge of this and did not tell complainant that the tenant requested to have tenant's son added to the lease. Complainant states that respondent never inspected the home during the lease term, even after neighbors called respondent to complain about damage done to the outside of the property. Complainant states that a neighbor attended the walkthrough after the second tenant moved out and took photographs of severe damage to the home, though respondents claim normal wear and tear. Complainant claimed damages from complainant's homeowner insurance company and provided estimates to respondent, who stated that complainant would have to try to collect them from the tenant. Complainant states that respondent would not assist in recovering costs associated with the damage from the tenant. Complainant states that the cost for repairs is $4,230 and complainant has lost 3 months of rental income and $850 a month. Respondent's principal broker submitted a response including the management agreement, lease agreement, and correspondence from their file for the subject property. Respondent states that the second tenant paid rent on time and in full, and respondent's office never received any complaints about the tenant and never had any notice that the tenant left the property or that the tenant's son moved in. Respondent states that the tenant did not make respondent aware of a water problem near the tub which damaged the floor as required by the lease. Respondent states that the damage was discovered during the walkthrough after the tenant vacated the property. Respondent further states that some of the repairs complainant is claiming were not items not caused by the tenant, including a rotten fascia board on the storage building and interior painting. Respondent states that the only damage noticed on the walls were nail pops that appeared to be a result of settling. Respondent states that the home was built in 1960 and routine maintenance and repairs are expected but not caused by tenants. The agent who worked with the complainants also provided a statement stating that the property management of the subject property concluded on June 30th, 2015, which was the last date the tenant occupied the property. Respondents state that complainant signed the original lease with the tenant and requested respondent to extend the lease when the tenant inquired if the tenant inquired if the tenant would like to purchase the property. Respondent further states that the items complainant listed for repairs, not included in normal wear and tear on the property, were valued at $885, and complainant was issued the $850 held in escrow. Respondent advised the complainant to file suit against the tenant for failing to report the plumbing issue per the lease agreement if complainant wants to recover the costs. Office of Legal Counsel reviewed the documents provided by respondent. The lease agreement states that the tenant shall, at tenant's sole expense, make all required repairs to the plumbing, range, oven, heating apparatus, electric and gas fixtures, other mechanical devices and systems, floors, ceilings, and walls whenever damage to such items shall have resulted from the tenant's misuse, waste, or neglect, or of the tenant's family, agent, or visitors. Tenant agrees to promptly notify landlord in the event of any damage, defect, or destruction of the house or the failure of any landlord's appliances or mechanical systems, and except for repairs or replacements that are obligation of the tenant pursuant to subsection A above, landlord shall use its best efforts to repair or replace such damaged or defective area, appliance, or mechanical system. Complainant executed the lease agreement as the landlord. The property management agreement was entered into with the broker of respondent for a term of April 4th, 2014 through April 3rd, 2015. Respondent provided photos of the property when it was listed and photos of the property during the walkthrough. The estimate provided to respondent by complainant totaled $3,845. Complainant sent an email to respondent dated April 19th, 2015, stating that complainant no longer wishes to continue to rent the property to the tenant upon expiration of the lease on June 30th, 2015. Complainant further stated that complainant no longer wishes to retain respondent services. It appears that complainant and respondent continued to correspond regarding the damage. It appears that respondent advised complainant that the $850 security deposit could be used to cover damages, and complainant would need to send a certified letter with a list of damages to the tenant, allowing tenant 30 days to pay for the damages. If not paid, lawsuit could be initiated. Respondent released the $850 security deposit to complainant on or about July 10th. The recommendation is to dismiss.
Motion to accept council's recommendation.
Second.
Well, we have a motion by Commissioner Hills, seconded by Commissioner DeChar. The council's recommendation be adopted and this complaint be dismissed. Is there discussion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 6.
20150224471. Complainant filed a complaint stating that respondent's firm is refusing to cancel complainant's listing agreement without receipt of a $100 fee. Complainant states that complainant plans to take the property off the market and has no intention of listing with another broker until possibly spring of 2016. Respondent is principal broker of the firm and states that an affiliate broker was the listing agent. Respondent states that the property was listed July 24th, 2015, and the first offer was received September 26th, 2015, but never became binding. Respondent states that after receipt of the offer, complainant asked to terminate the listing agreement on September 28th, 2015. Respondent requested the $100 cancellation fee from complainant and states that complainant became very upset and stated the fee was not ethical. Respondent states complainant told affiliate broker that complainant would not allow the property to be shown unless an offer was received for the full amount. Affiliate broker told respondent that affiliate broker did not want to continue to work with complainant due to the derogatory remarks made by complainant about respondent, and since complainant would no longer allow the affiliate broker to show the house. So a listing agency mutual release agreement was filled out on September 28th and executed by complainant on September 9th, 2015. Office of Legal Counsel reviewed the documentation. Per the fully executed listing agency mutual release agreement, complainant was not charged a cancellation fee. It appears that the complaint was filed on September 28, 2015, the same day complainant requested release of listing agreement, and one day before the complainant executed the release. The recommendation is to dismiss.
Move to dismiss.
Second.
We have a motion by Commissioner Frank, seconded by Commissioner Hills. This complaint be dismissed per council's recommendation. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Number 7.
20150224491. A complaint was filed by a former affiliate broker of respondent's firm. Complainant states that while at respondent's firm, complainant had a listing with a couple sellers who originally had their home listed as for sale by owner in order to save on commission and sell as quickly as possible due to a job transfer. Complainant states that sellers had originally met with an agent who is a friend of theirs who offered to list the home for a 5% commission, but they declined. Complainant states that sellers purchased their home in May of 2015 for $260,000, although it appraised for $262,000. Sellers had some work done to the house during the time in which they lived there and came to an agreement with complainant to list the property at 4% commission and for a purchase price of $274,900 based on the comparable sales. Complainant states that the seller signed the listing agreement on September 4th, 2015, and had a showing scheduled for the 17th. On September 14th, respondent called complainant and expressed concern that complainant accepted a 4% commission without respondent's permission. Complainant was unaware that respondent required approval and states that complainant sold a home with 4% commission to this transaction for which respondent did not express any concern. Complainant states that respondent and the company, this is a multi-office company, required a 6% commission and that complainant had to cancel the listing. Complainant states that the sellers are very upset and confused. Complainant states that sellers received a call after the cancellation from the first agent who had offered 5%. And complainant discovered from the sellers that the other agent works at the same office under respondent as well. Complainant states that yet another agent from the same company but at a different firm office location signed with the sellers at 4% commission for the same listing price. Complainant states that respondent accused complainant of outbidding the first agent in the same firm, although complainant did not know the identity of the first agent until after complainant canceled the listing. Complainant states that the respondent leased complainant from the firm and complainant lost an additional 2 listings. Respondent states that it is the company's policy to require broker approval for any commissions less than 6%. When respondent learned of the 4% listing without approval, respondent states that respondent instructed complainant to cancel the listing and states that complainant became agitated and verbally abusive. Respondent states that the conversation was short and respondent hoped to allow complainant to regain composure and follow up with the broker counseling session. Respondent states that complainant's behavior and communication quickly deteriorated. Complainant assaulted respondent and staff with lengthy calls, voicemails, text messages, and emails containing offensive language, slanderous and personal attacks, and reflecting unpredictable behavior. Respondent felt it necessary to ask complainant to leave the firm in an effort to safeguard the firm's professional reputation, values, and ethics. Respondent states that it is terrible the sellers were entangled in this situation, but respondent did not believe complainant was properly representing the firm. Respondent provided a copy of the listing agreement only signed by the complainant and states that complainant would not provide documents from the file after leaving the firm. In respondent's subsequent response, respondent states respondent continually asked for the completed listing file, but complainant refused to provide it after leaving the firm. Respondent did not want to contact sellers to get a copy of the agreement since they were now represented by someone else. In a phone call with Office of Legal Counsel, respondent stated that respondent never told complainant to fire the sellers, but it was clear they were unhappy since they quickly relisted with another brokerage. Recommendation is $1,000 consent order for violation of TCA Section 6213-4042 to be loyal to the interest of the client for requiring the listing agreement to be canceled.
So we're saying because the broker canceled it,
So
that's why they're violating the violation?
yeah, in the initial response from the respondent, who is the principal broker, the respondent said that respondent told the affiliate broker that the affiliate broker had to cancel the listing agreement because the commission was too low.
Okay.
Then in a subsequent conversation with our office, respondent said that respondent did not require the affiliate broker to cancel the listing agreement, and that the respondent never saw the signed listing agreement, which is why there was a problem. So the two responses don't really, they're different responses. So I put this recommendation based on the written response that we received from the respondent instead of the phone call that we got later.
So the complaint was filed by a former affiliate who was upset that he had to cancel the complaint with the listing agreement with these people, and yet the firm listed it with another agent for a higher fee.
Same thing.
Same
thing. Same thing.
Well, originally, an affiliate from the same firm had, according to the complainant, an affiliate from the same firm had offered a 5% commission, and the sellers decided, no, we don't want to do that. We just want to, do it on our own. And then this affiliate broker, the complainant, said, well, I'll do it at 4%, and they accepted that. And then, according to the complainant, then the principal broker said, well, you have to cancel it because it's not 6%, and you didn't get my approval for anything less than 6%.
But is there anything illegal with the broker doing that? Because isn't the listing between the broker,
It is. It
not
is.
the affiliate?
Yes.
So why couldn't the broker say, I didn't give you permission to reduce the commission?
Well, because I just think it's not very good to the sellers, the public, to say, well, you've had a listing, we've been working trying to sell your house for several days now, and now we're going to cancel our contract with you because you're not going to make us enough money.
Well, the problem was at my office, if it's less than 6%, you gotta have my permission to do it.
Mm-hmm.
And so if it comes in and it's 4% and they don't have my permission to do it, I'd have the same problem that this broker had.
Well, I mean, I understand that, but to me that seems like an issue between the principal broker, and that the sellers shouldn't have to take the hit for that.
So the complainant is who?
The affiliate broker.
So it's between an affiliate broker and a principal broker.
Well, that's who filed the complaint. But when I look at it as who was harmed here. And to me, the sellers were harmed because they had a contract with a company who was selling their house, and then all of a sudden it got canceled on them.
So how were they harmed?
Well, they were trying to get their house sold quickly, but then they had to start all over again because they had to find another agent.
But they agreed to finding another agent, right?
Well, I don't think they didn't have a choice because the principal broker made the affiliate broker cancel the contract.
So I would argue with you, the principal broker can't do that. The client has to agree. It's a bilateral agreement. Took two to get in, it takes two to get out.
Mm-hmm.
Yeah, I mean, that's certainly something to consider.
Okay.
It's hard to know without knowing how that conversation went between the broker and the,
Is that affiliate still at that same company?
though the principal broker made her leave.
Okay.
But does an affiliate broker signing a listing agreement make it binding, or is it the broker that has to sign it to make it binding?
Well, the listing agreement is between the firm and the client, but if the firm can let the affiliate broker sign the listing agreements, I would think.
But the principal broker, number one, had the rule, and then their only remedy was to, they had not signed it.
Who hadn't?
The principal broker
Principal
had not
broker.
signed it, right?
The affiliate broker signed the listing agreement with
On behalf of the principal broker without the principal broker's permission.
And you'd have to assume it would without the principal broker's permission, because they said no discounting.
Right.
I think it was handled very poorly, but I don't think there's anything we can do about it. That's my.
Is that your motion?
So
My
is
motion
it y'all's
to
view that the
vote
principal
to-
broker has to sign all the listing agreements?
No.
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 But I think we can make, in this case, the affiliate broker acted without the authority of the broker.
Yes.
So why should they be able to bind the broker to something they didn't have
Right.
authority to do?
That's true, and, you know,
And then turn around and file a complaint?
and I think it was handled very poorly, because if I'd have been a broker, I'd have worked something out, but still,
Yeah. I move to dismiss.
I'd
Second.
dismiss too.
Okay, I have a motion by Commissioner Franks, second by Commissioner Wood, this complaint be dismissed. Is there discussion on the motion? Further discussion? All right, let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, no. Motion passes unanimously. Number 8, please.
201502245111. Complainant rented a property through respondent's firm and states that after the lease term and during the walkthrough, respondent's firm designated that there were no major damages and the property was cleaned properly and would reimburse the security deposit. Complainant states that complainant paid a $975 deposit, but the firm deducted a $250 pet fee, a $150 carpet cleaning fee, a $150 cleaning fee, and refunded complainant $87.50 and complainant's roommate $337.50, even though complainant paid the deposit. Complainant states that the lease stated a cleaning fee would only be charged if it was outside the normal wear and tear. Complainant alleges that respondent owes complainant $575 for a refund of the security deposit. Respondent submitted a response stating complainant and roommate's relationship deteriorated over the term of the lease, and it was difficult to work with both tenants because of their animosity. Respondent states that complainant did not attend the move-out inspection, and complainant's roommate was advised that a cleaning service would be hired and the carpets would be cleaned per the lease. Respondent states that roommate agreed to both cleaning invoices, and an analysis for charges to the tenant security deposit was mailed to the roommate. Respondent states that although complainant provided the check for the $975 security deposit, complainant's roommate provided proof that the roommate paid for part of the security deposit. Respondent further states that per the lease, no pets were allowed in the property. When respondent's firm discovered the pet, both tenants were sent a letter regarding a $500 pet fine. Respondent states that the roommate paid the $250, but complainant had not, and it was deducted from complainant's share of the security deposit. Respondent provided 2 police reports filed by the roommate against complainant, a copy of the lease, and a copy of the correspondence. Respondent believes that both tenants were treated fairly and properly under the circumstances. Office of Legal Counsel reviewed the documents. The proof referred to by respondent regarding whether or not complainant and roommate shared the cost of the security deposit is a string of text messages between the two tenants where they're fighting about who owes what concerning the deposit and last month's rent. While it does seem to indicate that the roommate paid some amount to the complainant toward the security deposit, it appears that it was not a 50-50 split, as respondent indicates in the analysis of tenant security deposit account and refund, and it is the opinion of legal counsel that any remainder of the deposit should go back to whichever party wrote the check, and any division of that amount is up to the tenants to work out, instead of respondent trying to determine what is fair based on text messages between the tenants arguing with each other. The recommendation is $500 consent order for violation of TCA Section 6213-431, reasonable skill and care.
Ms. Taylor?
I think that once a deposit is given, it's not up to the landlord to decide, if they're both on a lease, to decide who paid what. So my deal would be to dismiss this. It's between the landlord and, I mean, that's not up to us to decide this.
Well, that's what she's saying.
No, well, no, I
She's saying
mean,
reasonable skill and care was not paid.
Yep, I don't even say that.
well, I mean, I think that if you pay the security deposit to the landlord, if I pay the check with my name on it to the landlord, then if any money is owed back from the security deposit, it should go to the person who paid the security deposit.
I agree with that.
And then it shouldn't be up to the landlord to decide, well, I think maybe your roommate paid you part for part of that security deposit, so that's why I'm saying the landlord shouldn't have split it up based on his own decision.
But the landlord's saying he split it up because one of them paid part of the pet money and the other one didn't? Is that what it was over?
Well, no, he's saying, so the check for the security deposit came from the complainant.
Okay.
The whole security deposit was paid by the complainant. He's saying he got some text messages from the roommate that to him showed that the roommate paid the complainant for part of the security deposit, and so then he decided to go ahead and split it up. However, I saw the text messages, and I don't think that's very clear, and I also don't think it says that there was a 50-50 split. In fact, it sounded like it was not a 50-50 split, and that's how he divided up the security deposit when he sent it to both parties.
I think a normal tenant would just talk to the other tenant and settle it. And I think that's the problem.
Yeah, because there's police reports involved in.
Yeah,
Yeah, the tenants had like major issues
yeah. That's the problem. And
with each
now
other.
the landlord's got drug into it because the tenants.
Well, it's my thought that when two or three tenants sign a lease,
Yeah.
and they give the security deposit to the landlord, it's not up to the landlord to say, oh, he paid $5 and he paid 10 and he paid 20. The landlord is just supposed to give the money back to the tenants. That's their problem to divide it up.
That's right.
It's not the landlord's.
And so if you have two tenants, that's a 50-50 split, that you return the money
That's exactly
50-50
right.
to them.
That's
And then,
exactly-
why not?
I think you return the check to whoever wrote the check.
Was there two checks or one check?
There was
There
one
was
check.
one
That's what
check.
I'm saying. The complainant is the only one that wrote the check, and it was the entire amount of the security deposit.
Let's talk
Okay.
about if.
But
we
yet,
pay-
when the landlord gave the security deposit back, whatever was left of it, he took it upon himself to divide it up between the two.
Okay. The security deposit goes, it's just like an escrow check. It goes back to the person who wrote it.
Yeah, and that's what this landlord didn't do. He
Right.
divided it.
All right,
It goes back based on what the lease says.
Yes.
right.
Well, the
Whoever's
lease has-
named the lease is in.
The
is who
lease
it
has
goes back
both
to.
tenants' names on it, but the security deposit was only paid by one of them in total.
That's what we think. That the check came from one of them.
You have proof of that?
Yes.
But we don't know what they worked
Yeah,
out.
we don't know what they were, and you don't know when they paid the
Well,
rent.
it's not
you know, how
it's not the
rent-
landlord's job to figure that out.
It's not.
I mean, the cleanest thing would have been just to write one check with both of their names on it and let them go duke it
And
out.
that's
Right.
what Mallory's saying.
I vote to dismiss. I make a recommendation to dismiss.
We have a motion by Ms. Taylor that this complaint be dismissed.
Second.
We have a second by Ms. Franks, who barely beat out Mr. Wood.
Let's get quicker.
You guys are gonna have to pick it up a little bit. All right, is there discussion on the motion? All right, let's vote. Those in favor of the motion, vote aye.
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 Pretty tepid.
We were slow there, sorry.
Those opposed, no.
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 All right, the chair believes the vote was 5 ayes
You want
and
hands?
and 2 noes.
No, I think you're right.
And so the motion passes. Number 8,
9.
9.
as I was saying, number 9.
2015-0224711. A complaint was filed against respondent who is the listing agent representing the builder seller in a transaction. The buyer is a licensed broker. Complainant states that a condition to the purchase required a tree to be removed before the closing and that the tree resided on HOA land. Complainant states that both agents, respondent and buyer, and the builder were members of the HOA board. Complainant states that respondent presented a motion to the board for tree removal and the builder seconded the motion. Respondent obtained estimates for tree removal prior to the board meeting and the buyer issued the check from the HOA for removal of the tree. Complainant states that the respondent and buyer are acting in an that respondent and buyer were acting in an ethical and honest manner. They both would have recused themselves from the decision on the removal of the tree. Complainant states that neither agent disclosed to the HOA board or members their interest in the tree removal. Complainant further states that this tree removal was never discussed at a board meeting prior to the purchase contract being entered into. Complainant states that the tree had been dead for over 6 years, and prior to the April 30th meeting, the board would not approve its removal. Complainant states that only one tree was removed per the meeting discussion, and though there are 2 to 3 hazardous dead trees on the property. Complainant alleges misappropriation of funds and has requested respondent and buyer to resign from the HOA board. Complainant alleges ethical violations and requests that respondent's license be permanently terminated due to conflict of interest between agents and the HOA board.
Ms. Kirby,
Yes.
is this complaint strictly about HOAs?
Indeed.
Move to dismiss.
Although it does involve some real estate transactions associated with the HOA, which is why I put all these details in, but essentially my recommendation is to dismiss because we do not have jurisdiction over HOAs.
So, sorry to interrupt, but
Bobby,
we've heard that enough from you, that HOAs are not in our purview.
And I second Bobby's motion.
And so, let's not wear it out if we don't have to. I've got a motion by Mr. Wood, second by Mr. Char, that this complaint be dismissed per council's recommendation. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Let me see, number 10.
2015-0226261. TREC opened a
Motion
complaint.
to dismiss.
Second.
For the audience's benefit, this is a complaint that was filed against the principal broker of the agent involved with the HOA in the previous complaint. And since we did not find the agent in the previous complaint culpable, it's hard for this commission to fine his principal broker for something the agent didn't do. That's why the complaint was made so quickly, the motion was made so quickly. And as I recall, it was made first by Mr. Char, seconded by Ms. Franks. Is there a discussion on the motion to dismiss? Let's do it. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously.
201600391 and 201600451. Complaint was filed by a previous complainant in case number 20150224711 above. Respondent 1, hereinafter affiliate broker, was the buyer agent in the subject transaction. The complaint is filed is identical to what is summarized above.
Move to dismiss.
Yeah.
Both
Second.
respondents.
Okay, so just to be clear, this is the same HOA?
Yeah, so we have, there's an agent, the agent in the first complaint, or the first set of complaints, was the agent representing the subdivision that was also part of the HOA. These 2 agents were representing buying a home in the subdivision as a personal property, but also this person is an agent. So it's the same issue, just we have 4
The
different
tree?
parties. What?
Is it the issue about the tree?
Is it about the tree, yeah.
Okay. Okay, we have a motion by Ms. Frank, seconded by Mr. Chara, that this motion against these 2 complaints, 2 respondents be dismissed. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 13.
2015-022-4821. TREC voted to open a complaint against respondent with regard to case number 20150175551, which was presented in October 2015 against principal broker as follows. Complainant states the complainant 3 times requested a withdrawal form from respondent for properties complainant and complainant's wife have listed with respondent's company. Complainant states that upon the 3rd request, respondent told complainant that respondent had looked in complainant's files and there were no contracts. Complainant states that respondent made every excuse for not sending a withdrawal form, and complainant advised respondent that he would make a complaint with Trek. Respondent stated that he would have to talk with the agent who had complainant's listing. Complainant Complainant states that respondent is interfering with complainant's right to relist his property, and respondent acted in an unprofessional manner. Complainant states that complainant does not have any copies of the contracts, and that when complainant contacted the agent taking care of the properties, they stated they had been locked out of the computer system at the firm and could not provide copies. Respondent states that on May 29, 2015, the owner and manager of the firm decided to release the principal broker of one of the branch locations because of lack of documentation and record keeping of contracts and offers. Respondent, principal broker at a different branch location, states that within an hour of being informed of the other principal broker's release, the office began receiving requests for mutual release forms so that the client could relist with the released principal broker. Respondent was asked by the owner to assist with the transition, including dealing with the request for release, because the owner was going to be out for a couple of weeks for medical reasons. They decided that anyone who requested a lease would be given one, but because it made long-term business sense. Respondent states that many of the documents were missing from the files, and the clients indicated they were never given copies of the documents they signed. Respondent states that this was unacceptable because the company had adopted .loop to ensure that clients received and could save signed copies. Respondent states that the respondent spoke to complainant via phone on June 14th, and complainant indicated that complainant had sent an email several days prior upon further search. Respondent found the email in the spam folder. Respondent states that respondent told complainant that respondent would send the mutual release forms, which respondent was under no obligation to do. When complainant called again a couple of days later, respondent told complainant that the previous agent failed to keep adequate records for his properties, including listing agreements. So respondent had to search several different avenues to be sure they had the correct dates and descriptions. Respondent asked complainant to send copies of the listing agreements, but complainant did not have copies. Respondent states that complainant became confrontational and told him that it did not matter what information respondent did not have, but that respondent needed to get complainant the forms, or complainant would file a complaint with TREC. Respondent states that respondent then told complainant that respondent would get complainant their forms as soon as respondent had the information reconstructed, and in the interim his property remained active and an offer or interest would still be in the benefit of the previous agent. Respondent then contacted the previous agent, who said she did not have any did not have any of the files or documents, but should be on .loop or in the office. Respondent then went back to the other office and looked on .loop and in the physical files a second time and found nothing. Respondent then contacted the local association of realtors, who assisted respondent in constructing a timeline for the properties. Respondent prepared the mutual release forms for the client and sent them to the client on June 24th. Respondent included the mutual release forms as well as statements from the firm owner and the owner's assistant, stating that the owner had to take over as principal broker and make changes in the office because it was not being run properly by the principal broker. The owner states that they sent out letters to as many of the clients as they could find contact information for, and 2 of the 3 letters sent to complainant came back as an incorrect address. The owner states that complainant told the owner complainant wanted the listing removed, and the owner then referred it to respondent to handle because the owner was going out for surgery. That recommendation was to dismiss, and the commission decided to adopt the recommendation of legal counsel and open a complaint against the principal broker, which was released. Per the request, a copy of the complaint was sent to respondent, who is the released principal broker. Respondent states that respondent was owner-broker of the previous firm for 13 years until it was bought out by another company along with 2 other locations. Respondent states that the new owner of the firm did not provide items that the respondent needed in order to run the office properly, and states it was difficult working for the new owner. Respondent states that the owner did an internal audit of the firm's files a few months prior to this incident and found everything in order. Respondent states that per owner's request, respondent learned how to use .loop for file storage. Respondent went to a closing one Friday and was locked out of respondent's office upon return. Respondent received an email stating that respondent's spouse, who is also an agent, and the secretary were terminated and could come pick up their items and TREC 1 forms the following Tuesday. Respondent 1 states that the owner would not state why they were terminated, would not respond to respondent's request for access to active files respondent was working on, and therefore could not assist clients. Respondent was advised on Tuesday that they were being terminated because they were going to work for a different company. However, respondent denies that respondent and spouse were planning to leave the company. Respondent hired an attorney to assist in receiving the active documents and ceased saying terrible things about respondent to respondent's clients. The firm released some active files on .loop at the request of respondent's attorney, but not all of them. Respondent states that many of the clients were respondent's clients at the previous firm. Respondent states that complainant was a client from the previous firm and requested to withdraw the listing from respondent's old firm when respondent and spouse were terminated. Respondent states that complainant would not use .loop and the contracts were executed and exchanged by email, but respondent could not access the files to provide to complainant. Respondent states complainant wanted to move their listing agreement to respondent's new firm, but respondent told complainant that the complainant had to talk to the new owner or the principal broker referenced in the complaint, since respondent no longer had access to any files. The recommendation is to dismiss.
Move to dismiss.
Second.
Ms. Franks has made a motion to dismiss this complaint. It's been seconded by Ms. Hills. Is there discussion on the motion? All right, those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 15.
14.
I was thinking about skipping around a little bit. Number 14. Okay.
2015-022-4951. Complainant purchased a property and states that it was listed on the MLS as a 3-bedroom house, but the 3rd bedroom did not have a window. Complainant states that upon attempting to obtain a permit for the window, complainant was informed that the home was a 2-bedroom home, and the permit cannot be issued due to lot constraints. Respondent was a listing agent of the property and states that neither buyer nor buyer's agent have contacted respondent regarding their concerns. Respondent denies any misrepresentation concerning the number of bedrooms or any other information concerning the sale of the property. Respondent states that the seller placed the property on the market on July 1st, 2014 and executed the agency relationship documents, including a property condition disclosure and update. Respondent states that the MLS noted 3 bedrooms because it was what the seller represented. Respondent states that the room at issue is a finished room off the den in the basement that has an HVAC and a closet. Respondent states that the seller told respondent that the main floor originally had 3 bedrooms, but a wall was removed to make the living room larger. Hence, it is strange that the county code office would not allow the property to be a dwelling with 3 bedrooms. Respondent states that during the time in which the property was shown or listed, respondent was not approached with questions regarding lot size, possibilities for remodeling, addition of windows, or bedroom capacity. Respondent denies misrepresentations to complainant regarding window installation, stating that there was never a conversation regarding the same. Respondent further states that before listing the property on the MLS, respondent pulled the courthouse records to confirm the year, bill, ownership, size of the lot, etc., and states that the number of bedrooms was not listed on the courthouse data. Respondent fully understands that it was respondent's duty to inform parties to the best of respondent's knowledge. Respondent had no knowledge regarding usage, ability to pull a permit for window installation, or lot constraints. Respondent denies wrongdoing. Office of Legal Counsel reviewed the transaction documents. The MLS states that it is a 3-bedroom home and basement includes a family room, den, office, library, 1 bedroom, and a garage. The first level included 2 bedrooms. The MLS further states that the property contains a partially finished basement. The property report from the property assessor's website was printed on June 30th, 2014 and did not include a reference to the number of rooms. It appears, per the contract, that complainant had a home inspection, however, it was not provided. The recommendation is to dismiss.
So moved.
Second.
I have a question.
Let me, for the record, we have a motion by Mr. Chara, second by Ms. Hills to accept council's recommendation. Ms. Franks.
So I learned this from Wendell Alexander, that not everybody has the same codes. So I'm wondering, because where I live, codes dictate that a bedroom has to have a window. But, so is the question about codes and what was allowed?
Well, I think the question this body has to ask is, did the agent know that it's not a 3-bedroom house, yet it was advertised as a 3-bedroom house?
So can you?
Because they're only just required to disclose things that they actually know.
Okay, well, so was the room being used as a bedroom?
I believe so. Just a bedroom without a window.
Okay, so it was 3 bedrooms. So then I don't understand the problem.
My question is, was the house on a septic tank?
I have no idea.
Because I'm trying to figure out why is it a 2 or 3?
That would
and it's
dictate it in my
septic
county.
tank?
Well, it's saying because of the lot,
And the lot would mean
the
septic
size of
tank.
the lot, I guess, I don't know.
Yeah,
But other areas require the lot size to determine. So, I mean, you're right, Marcia, it just depends on where it is, but it could be that it doesn't handle it because of the field lines.
But also the agent only can tell you what she knows in her expertise. And
Can you
so
t-
I think there's a lot of unknowns here
Yeah.
that we can't
Yeah.
make a
can you
real
tell us what
judgment
county?
on.
No.
No. I mean, I don't know, but even if I did, I don't
Couldn't
think I could tell y'all.
Because the county would tell me whether they had codes or not.
Yeah.
Well, not necessarily.
I don't know what the county has.
Okay.
I mean, I would have to look back at the paperwork, but I don't think we could
Okay.
disclose that.
So the question is, did this agent misrepresent what she was trying to sell?
Do what?
The question is, did the agent misrepresent what she was trying to sell?
Correct.
And she represented it as a 3-bedroom home.
Because that's what was being
Or, I
used.
mean, if this commission thinks that that's something the agent should know and didn't do their homework, then that would be potentially a different violation, but it could still be.
Well, I think the issue is whether it's in Marsh's county or my county.
Or Wendell's County.
We
Yeah.
are gonna have different codes, so we don't know.
And what year it was built.
We don't know.
and-
There's too many
So I
unknowns.
would
Yeah.
say dismiss.
I mean, we have, so the agent pulled up the property assessor's information, and it didn't have a number for the number of bedrooms.
That's
Oh,
not,
wow.
but if it was on a septic tank, it would say how many bedrooms it was approved for. I mean,
Depends on when it
I'm
was
trying to
built.
think
It
why
would
you.
perk for.
Yeah,
Depends on
Now,
when it was
ours
built.
does, I mean, we have to request
Yeah,
it.
yeah.
It's required.
We have to.
but you have to ask, it's part of your inspection period, you get that.
Why do I list?
I'm trying to figure out why they wouldn't let you put a window in.
Well, if it's
Below grade.
Well, but that wouldn't be a window then, would it?
In our
It'd be a
area, it'd be the
submarine.
size that it would be.
All right,
All right.
just to remind commissioners, we
guess it'd be a
have a
more
motion to
window
dismiss, probably made and seconded. Is there further discussion? We're going to vote. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no.
No.
Motion passes on a 6 aye, 1 no vote. And
I have a question about that. I guess I was just thinking, like, I don't know why it would matter how many bedrooms there are, because if it's just regardless of what kind of room it is, if they want to put in a window, and that's a
Well,
window,
that
that's
does
another issue, I feel like, than the number of bedrooms that it's allowed
It goes
to
to
have.
the, it goes to the sellability of a house. A 3-bedroom
Right.
house versus a 2-bedroom. There's a whole lot more people looking for a 3-bedroom than a 2-bedroom.
Right, but they weren't trying to add a bedroom or anything. They were just trying to put a window in a room that was already there. So
And
that's the weird.
And I keep making this assumption, but if it was on a septic system, then a septic system, depending on the quality of the soil and the percolation rate, dictates how many bedrooms you can call
Yeah.
it. Now, there are a lot of places that look like 3 bedrooms, but technically they might be a 2-bedroom with an office. Okay,
And the soil may perk and they only put in so many feet of lines.
That's right.
That
That's right.
they short it.
I mean,
Yeah.
that's the question.
Is it
If you
possible?
found out about the septic system, I think that would give the answer.
Well, in rural West Tennessee, we have houses that don't have septic tanks or any kind of letter from the septic department. So, not knowing what part of the state this is from, that's gonna be hard to determine.
But on her behalf, and the next time we have something like this,
Yeah.
you might look and see if you can see what county it is.
Okay.
All
Well, that's
right,
what I'm saying. I mean, even here, it's not that the counties don't now have regulations, but if it's an older house, there wasn't any
Right.
that many years ago.
Did we vote?
Call for the
No.
No,
question.
I'm trying to get to that.
Yep. We did vote.
Yeah, we did. Bobby voted against
Yeah.
it.
Oh,
Yeah,
that's
yeah.
right.
That's right.
I got
6-1.
I got distracted in that comment you made, Mr. Char, about West Tennessee houses with no sewer or septic tank. That's where I was confused.
I have actually sold one that was FHA that had a 50-gallon barrel for the septic tank.
And
When
that's not on our agenda today, so let's move on to the next item. We're gonna take a break here in just about as quick, just watch how fast we're gonna take a break. Next item,
Yeah.
please.
2015-022-4951.
Motion to dismiss.
Got a motion by Mr. Char, a second by Ms. Hills. This complaint be dismissed. It's against the principal broker or the previous agent who we did not find fault with. If you're in favor of that motion, vote aye.
Aye.
Vote, if you're opposed, no. The motion passes unanimously. We'll take a 10-minute break.
Okay, I read the wrong number. Sorry.
I don't think you did. Are you sure?
I did. I read the one we just did. Let me just read the number
Okay.
to associate with that vote. So it's 2015-022-4971.
Let the record so reflect. 10-minute break.
That's cool.
We have grapefruit, we have chocolate.
That's cool.
Did you
Yeah,
bring us
we
some
are.
sweet? Marco?
Yeah, we are.
Stuff in there.
Well, I have guacamole and sour cream in there for y'all.
Cinco de Mayo.
That's right.
It's my marker. I know, right?
Excuse me. Are you from Chattanooga?
Now, you do understand if we keep using this technology here, then the state's probably gonna have to pay for your manicures. Keep seeing your name. You have to write that off. You have to write that off. Turn it in. Just turn it in. Just turn it to the state. I'm sure they'll take care of it.
Well, I still want to talk to Cindy because I think that those guys are masterful at settling. So I agree. not gonna fight anybody on that one, but that's how it feels to me.
Yeah, because I think those rates they covered in the quote was pretty standard, because I know in Louisiana we had the averages.
So we'll get to it.
I ran against the
Actually, I'm getting into these cases today.
You are?
Okay, like the affiliate broker decided to charge a lower commission rate than what was set by policy of the broker. And didn't file a claim against the broker.
Oh, yeah.
Really?
Yeah, you do that, and that's what you
Actually, I met one of my victims of my consulting earlier.
really.
It was
Here, I'll trade you if you want a copy of it.
people,
I need to sign one.
what did I say? We were at a strategic planning session last year.
Do you sign the final page or this side? Okay.
It's kind of neat thing.
Bruce, have you signed the front page and the second page, sign and date? I need to have the date for you. Have you already spoken with Ms. Rachel Fowler? Okay, that's all. Thank you. Yes, sir. If you have not paid your fines, make sure you send them to our.
I've seen it. Okay, that's it.
Hey, I'm at break, and I have a voicemail about seeing one of Jerry Smith's listings on Bolton. Are you interested in it? They're asking for this afternoon. Okay, that's right. That's right. Okay, that's not a problem. I just thought about you, so. I know, that's okay, that's all right. All right, I'll call BJ, okay? All right, thanks.
Okay, next. Here we go. I can only sign the front page, initial front page, sign the back, and the dates. Initial it again. Here's your sign. No, you need that page signed. Yes, ma'am.
Hello. Are you interested in calling a client to show a client one of Jerry Charlton's listings? That would be your client. Okay, I'll just forward you this message. It's an email message, and I'll forward it to your email. Okay? All right, and I may be coming home tonight.
Jessica. Thank you.
And they emailed this back to me after being signed. I don't know, you have something else?
You did not sign from me.
Oh, okay, maybe that's what it was. I didn't know if I need something else from you or. So do I just have to send this?
No, you just give it to me.
I just give it to you?
Yes.
Okay, all right.
I'm good?
All right, I'll send this to you, okay? All right, thank you, BJ. Bye-bye.
That needs to be turned into our office.
They didn't leave a message on my email, it left on my voicemail, so let me give you the number. You tell me when you're ready.
You can send them together, I just don't want them to get confused with the payment and the check. So if I were you, I would write on some
That's all right.
this is my receipt. You can make sure that your check is attached to that. Yeah, there's certainly is the same, and I'll probably yeah.
Okay.
So there's that,
All
and
right.
I put an initial here.
Yes, ma'am, and sign date, we're good there.
Okay, and so, and then I just need my, and I've already sent my
Do
check
what? What'd you
to
say?
Nashville, so we're good.
Oh, okay. Okay, all right, thank you. All right, it's
So I'm still good.
276.
Because I've already paid and done all that.
83.
So I don't need to email you.
No, And I forgot her name, but there are two properties on Malton, and it's one of the two properties, and they're side by side, so I'm not sure which one. They're both vacant, and they're both little houses.
Yes, sir.
Okay, all right.
We've turned you over.
All right, thank you, BJ. Bye-bye.
I know, but.
Okay. Oh, no.
Let's say maybe like at 3 o'clock.
Plus, I need to run downstairs. Like, I need to find you. She said, I have her check again. And then she said, I'm just, I'm not sure. You got it right there. And then she said, send it back. I'm like, yeah. I was just.
Well, and I have trouble hearing you.
Very funny.
At least 3.
What did you bring back, John? A cookie? Where did you get that cookie? Oh, you were smart, weren't you? I didn't realize that. For the late afternoon. I get
Well, if you want.
No, that's okay. Thanks, Johnny.
All right, well, this is what I'm glad I've read these.
Oh, yeah?
No, cookie's not my thing.
Rattle chocolate.
think of like one of those little kisses or something like that.
Look at my dresses and flowers on this chair.
Let it melt in the
Depending on the month, sometimes she does more than someone budget.
What do y'all do about it?
Okay. I need more messy.
But I figured, I didn't know if you use
Yeah, I've got,
How many more minutes?
this is the first one I've been in. I'm thinking, listen. Oh, I've already been to one.
No, I mean, before we start back, when we get ready.
Right now,
It's very time consuming.
Okay.
we have all commissioners present. Now, we're going to step outside of this legal hearing. What do we call this session?
Legal report.
Yes.
And Ms. Kirby has a report for members of the commissioners that will probably make no sense to the audience, and that's okay. Related to an executive session we had this morning. Ms. Kirby.
Yes, so I'm just delivering the status of the ongoing litigation from the Attorney General's office. The motion for stay was granted this morning. So that's all I need to say about that. We don't need to discuss anything further. I just needed to relay that to y'all.
Thank you.
2015-022-4951. Sorry, we already did that. We already did the next one.
16.
16.
Number 16.
2015-022-4991. Complaint was filed by a potential buyer stating that an offer was placed through complainant's agent on September 26, 2015, but respondent had not presented the offer to the bank as of October 12, 2015. Complainant had not received an update from complainant's agent, so complainant contacted respondent directly. Complainant alleges that respondent refused to submit the offer. Complainant states that respondent called the bank to discuss the offer, but respondent would not release the name of the individual respondent spoke with. Respondent states that the offer was received and complainant's agent was advised that the seller bank would not accept offers without a commitment letter. Respondent states that complainant's agent requested to speak with the bank representative directly, but respondent did not wish to release that information. Respondent states that upon listing, respondent received instructions from the bank representative that the bank would not consider offers receiving an FHA or rural housing loan due to the property's condition. Respondent states that the driveway was severely washed out, there was an active roof leak that created swollen walls, damaged carpet, and mold. Respondent states that the problems with the water heater, electric, and HVAC were also suspected. Respondent informed complainant's agent that the bank would not consider an FHA or rural housing loan and requested that complainant provide a commitment letter from a lender with a conventional loan. Respondent states that at the time the offer was received, there was very little activity on the property, and respondent only wished complainant success in receiving a commitment and providing an offer that the bank would consider. Respondent provided the communication with the agent, and it appears that respondent clearly communicated the bank's position regarding the FHA loans on this foreclosed property. Respondent's principal broker also provided a letter from the bank seller stating that the property was on 16 acres and in a state of serious disrepair. The bank states that the respondent was instructed that all offers must be accompanied by an acceptable financing letter for the buyer. Further, the bank would only look at conventional offers or house construction loans due to the condition of the property. It is the bank's opinion that the property would not pass a VA FHA inspection and the bank would not entertain offers contingent on VA FHA lending. Rule 1260-02-.08 states a broker or affiliate broker promptly shall tender every written offer or purchase or sell obtained on a property until a contract is signed by all parties. However, pursuant to TCA Section 6213-404, respondent must obey client's instructions and be loyal to the interests of the client, except in violation of 6213-402. Recommendation is to discuss. Legal counsel will refrain from making a recommendation to defer to commission's industry expertise.
What say you?
Move to dismiss.
Second.
Discussion? All those in favor, please say aye.
Aye.
Opposed? Motion passes.
2015-022-5011. TREC opened a complaint against respondent for failure to supervise the previous respondent in case 201522491 above.
Motion.
Second.
Discussion? All those in favor say aye.
Aye.
Opposed? It's unanimous. There again, another broker, and the previous one was dismissed.
20150225041. A complaint was filed against respondent who manages the HOA of a subdivision. Complainant states that respondent's license is currently expired and states that it needs an active license to fulfill the contractual obligations to the subdivision. You're welcome to cut me off at any time because this is about an HOA.
Well, I wasn't sure if it was going somewhere.
Well, it's short. I can just read it.
Okay.
Respondent states that the company allowed the license to lapse in 2015 since it's solely managing only homeowner associations. Respondent denies being in the real estate business any longer. Complainant failed to submit proof of violation of the Broker Act on part of the respondent. Office of Legal Counsel reviewed the respondent's website, which states respondent provides management services for community associations. The recommendation is to dismiss.
Move to accept council's recommendation.
Second.
So I have a question. So, HOAs do not have to have a licensed person to run the HOA, but a property management company does.
Well, the HOAs don't lease properties or buy or sell properties. They're just handling the dues and stuff for the association.
And
So it doesn't really
maintenance.
fall under real estate.
Okay.
Have a motion properly made and seconded. Motion made by Commissioner Wood and seconded by Commissioner Taylor. Is there any further discussion on the motion? All those in favor of dismissing, please say aye.
Aye.
Opposed? Motion passes.
2015-0225111. Complainant submitted an offer to purchase a foreclosed property and alleges that respondent held the offer and did not submit it to the bank seller. Complainant states that the offer was submitted at $65,000 and that $25,000 in repairs was needed. Complainant states that the bank is required to reject the bid, submit a counteroffer, or accept the bid in writing, but this is not occurring. Complainant states that complainant had the same problem with another agent not submitting complainant's bid to the seller on another property. Complainant states that the offer to purchase the property was received from complainant's agent on October 12, 2015, and was submitted to the seller. Respondent states that the offer was in the amount of $65,000 with 100% FHA financing, and the mortgage company did not state the amount they were willing to finance. Respondent states that the MLS listed instructions to agents including terms acceptable to the seller of cash offers or conventional financing. Respondent also states that complainant stated the home needed $25,000 in repairs, even though the MLS clearly stated the property was being sold as is. Respondent states that FHA requires the seller to make any repairs at seller's expense, and the seller was unwilling to make repairs. Respondent states that although complainant's offer did not meet the seller's requirement, respondent presented the offer since respondent has a duty to do so. Respondent states respondent has no control over whether the seller responds, if at all, and cannot force the seller to respond in writing. Respondent further states that the seller did submit a counteroffer for $84,000 cash purchase, which is what the property eventually sold for to another buyer. Respondent is sorry the complainant lost the home, but states that it's not the fault of the listing agent. Office of Legal Counsel reviewed the documentation, and it appears that the offer was uploaded to the online document system on October 20th, 2015, and it appears the respondent forwarded an $84,000 counteroffer to complainant's agent on October 21st, 2015. The offer from the successful purchaser was received October 22nd, and the binding agreement date was October 23rd with a closing date of November 9th. The recommendation is to dismiss.
Move to
Motion.
dismiss.
You got it.
Well, I have a race going up here. Commissioner Frank's motion to dismiss, and I have a tie for a second down here between Commissioner Hills and Taylor. So,
She can have it.
any other,
This is not a contest.
any discussion on the motion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
20150225131.
Move to dismiss.
Second.
Motion made by Commissioner Grease to dismiss and seconded by Commissioner Hills to dismiss. Any discussion on the motion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
Complainant hired, 20150225191. Complainant hired respondent as buyer's agent and states that respondent worked against complainant in the purchase of the property. Complainant alleges that respondent violated their agency agreement by disclosing confidential information to the seller. Complainant further states that respondent had several conversations with respondent's sister-in-law, also violating their agency relationship. Complainant states that respondent ignored complainant's repeated statements regarding complainant's money being tied up due to a small IRS issue and instead assisted sellers in filing a lawsuit against complainant. Complainant alleges that respondent provided legal advice and slandered complainant's name. Respondent states that complainant's sister-in-law had been a personal friend for 10 years. Respondent was referred to complainant's spouse, and respondent sent 26 listings via email to complainant and spouse on September 21, 2015. Respondent began showing homes to complainant's spouse on September 24th in the price range of $510,000 and up to $799,900, while complainant was out of state. Complainant's spouse indicated that they would be paying cash for the home and stated that complainant had a music contract for $1.3 million. Respondent states that complainant and spouse placed an offer which was negotiated and became binding on September 28th. Respondent states that the purchase and sale agreement stated that the buyer would furnish proof of funds to close by bank letter within 5 days, and trust money in the amount of $5,000 will be paid by the buyer within 3 days. Respondent states that respondent struggled from October 2nd through October 22nd to obtain items required in the contract so they would not be in default, and denies violating any agency laws. Respondent denies relaying confidential information to seller's agent and states that respondent never met or communicated with the sellers. Respondent states that after many failed attempts to get complainants to provide the bank letter and trust money, the sellers were patient and willing to wait for complainant's funds to be released so complainant could comply with the contract. Respondent denies threatening complainant or spouse with any kind of lawsuit against them. Respondent ceased all communication with the complainant and spouse upon receipt of complainant's message threatening to file the TREC complaint. Respondent further states that complainant's spouse signed the confirmation of agency, residential property disclosure, exclusive buyer's representation agreement, and disclaimer notice. Respondent emailed these documents to complainant who agreed to sign when in town but never came in town. Respondent denies speaking to complainant's sister-in-law, stating that would have been improper. Respondent states respondent was discreet in relaying information to seller's agent, stating that the complainant had an unforeseen holdup and was diligently working on getting the funds. Respondent asked complainant to provide documentation regarding the funds, which may have been helpful in getting the sellers to extend the contract but never received anything. Respondent denies working with the sellers to sue complainants and states respondent has no knowledge that complainants were ever sued. Respondent denies providing legal advice to complainant. Respondent denies slandering complainant's name, stating that any conversations about complainant were with respondent's principal broker and they only discussed facts. Respondent states that complainant fired respondent and respondent notified seller's agent who requested complainant's number. Respondent states that respondent was in a state of constant worry regarding the defaulted contract and worked harder for complainant than anybody else. Respondent denies all allegations. Respondent submitted statements from complainant's sister-in-law and the seller's agent in the transaction. The seller's agent states that sellers did consult with an attorney regarding filing a lawsuit against complainants, but discovered that complainant and spouse had no assets and no possible way to purchase a home priced at $1 million. Seller's agent states complainant was a scammer and threatened to sue all parties, and this transaction was one of the worst experiences. Seller's agent reiterates that respondent acted in good faith and never acted outside of agency. Seller's agent states that respondent is a terrific agent who was caught in a horrible situation. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion made by Commissioner Wood and seconded by Commissioner Hills to dismiss. Discussion on the motion. All those in favor say aye.
Aye.
Opposed? Motion carries.
20150225211.
Move to dismiss.
Second.
Motion by Commissioner Franks and seconded by Commissioner Hills to dismiss. All those in favor say aye.
Aye.
Opposed? Motion carries.
20150225951. Complainant alleges willful misrepresentation, pursuing a flagrant course of misrepresentation, paying and accepting undisclosed compensation, and improper and dishonest dealing on the part of the respondent. Complainant states that the HOA is passing incorrect information to community regarding for sale signs. Complainant states that respondent spoke to the HOA meeting using a scare tactic to senior citizens to not sell their homes for such low prices and providing incorrect information regarding signs. Complainant further states that respondent resides in a neighboring state and has a vacation home in the community. Complainant states that respondent uses the HOA office and other resources not belonging to respondent without payment. Complainant provided a copy of an HOA amendment provided for voting, which states real estate signs posted on and in the property by brokers' owners. TREC mandates compliance to rules for signage by brokers and owners. If broker signs are not allowed, owner signs are not allowed. The vote was whether or not real estate signs for sale posted by brokers' owners on the property are allowed or not allowed. Complainant also included a photo of respondent's yard signs, perhaps implying there's some sort of misrepresentation on it. Regarding the allegation that the HOA is passing incorrect information to the lot owners, respondent is not on the HOA board and is not aware of any incorrect information being disseminated by them. Respondent owns 2 lots and does not feel that incorrect information is being provided by the HOA and believes that the complainant should address concerns with the HOA. Respondent further states that as an owner of 2 lots in the subdivision, respondent has the right to voice respondent's opinion at the HOA meetings for matters that concern the subdivision. Respondent denies attempting to scare owners out of selling their properties, but has suggested to some owners they price their lots higher and other owners to price their lots lower. With regard to respondent's yard sign, respondent states that the subdivision used to have their own firm license, but it expired after the principal broker retired. Respondent was approached by the board of directors about obtaining and placing respondent's license with the subdivision. Respondent chose to start respondent's own firm instead of reactivating the previous firm license. Respondent's firm was established as the broker firm for the subdivision and received permission from the HOA to place the subdivision logo on the yard signs. With regard to the voting of Amendment 3 on the for sale signs, respondent states that the lot owners voted on October 17th to remove all sale signs from the subdivision. Respondent states that all signs were removed before the close of business on October 17th, and the only sign left is the office sign at the front entrance of the subdivision to be compliant with Rule 1260-02-.03. Regarding the allegation of undisclosed compensation for office use, respondent states that the common areas belong equally to all lot owners. Respondent lives in a neighboring state and holds licenses in both states. Respondent conducts almost all of respondent's business from the out-of-state office, and the Tennessee firm is open by appointment. Respondent does not charge salary and in turn receives use of the office. Respondent denies improper and dishonest dealing and states that complainant has not been involved directly with any of respondent's transactions. According to TREC records, respondent is a non-resident principal broker. The real estate sign provided by complainant includes respondent's firm name, telephone number, and an additional phone number. There is also an additional email address and a website below this information. To the left of the name of the community, to the left is the name of the community and the respondent's name with the word broker below. There does not appear to be any advertising violations or otherwise on the part of the respondent. Recommendation is to dismiss.
Move to dismiss.
Second.
Motion made by Commissioner Woods, seconded by Commissioner Hills to dismiss. Do I have any discussion? Hearing none, all those in favor, please say aye.
Aye.
Opposed? Motion carries.
20150226641. The
Okay, now, before we get too far into
Sure.
this,
Yeah.
this is an HOA deal, right?
Yeah.
Sort of. It involves an HOA, but the respondent is the broker for the subdivision.
Exclusive broker for a subdivision?
That is my understanding.
Okay, so we've heard it previously, we came to a decision, and now you've got new information, is that right?
Oh, you mean the one we're about to do?
Yeah.
Oh, sorry. I thought you were talking about the one we just did. I'm sorry. So this isn't new information. This was open. This is a different party to the events that took place that are different than the one that was last presented. I don't know why we didn't have this with the other ones to present all together. They arrived to us at different times, so.
I'll make sure we're talking about number 24.
Yes.
Okay. So
So this one has not been presented before, but the facts have been presented in regards to another person involved in the transaction before.
Oh,
Because there's a recommendation and then a decision,
Yeah,
and
so
then
it's
another
presented March
recommendation.
2006. What you're saying is one person was left out, one tree of the branch of the
Right,
tree.
so with the one we presented before, the complaint involves a couple of different parties that the complainant is complaining about. The original complaint that we had was only against one of them. They had filed one against this other person as well, but we didn't have it up in legal at the same time we had the other one. So this is just the other party involved with basically the same facts, which is why I put all the information from the previous one.
So can you just kind of do a summary and then read the new facts?
Sure. So it's a property management agreement. The agent that was doing the property management left the firm, started his own firm, and the contract was transferred to the new firm. This person, this respondent, was an assistant that went to work for the new firm, but also was finishing up a contract as the HOA administrative assistant, and the complainant thinks that that's a conflict of interest and had some other complaints against the broker that were dealing with, I'm trying to remember what the exact, basically about terminating the property management agreement. This person happens to be also licensed, but she was working as an administrative assistant for most of the time.
Move to dismiss.
Do I have a second?
I'll second.
Okay, discussion on the motion. Anything? Okay, motion properly made and seconded. Motion made by Ms. Franks and seconded by Ms. Taylor that we dismiss. All those in favor, please say aye.
Aye.
Opposed? Motion carries.
20150226671. TREC opened a
Move to dismiss.
Second.
Discussion on the motion.
It was the principal broker for that last case.
Well,
It's the same principal broker though, right? For the one before? I mean, the other, We
Okay.
get these ahead of time.
So
You've
the-
got a recommendation on this one.
Right, so the original
Not to
person that this
dismiss.
complaint was against was a broker who was the owner of the new firm. This is the principal broker, which we didn't have the complaint against the principal broker when we presented the first one against the broker. Like I said, I prefer to present them all at once, but we didn't know at the time we presented the other one that these other two had existed. So, there was we found in the previous presentation for the broker owner that there was a trust money violation. That it was not
I'd like to hear that.
provided to the person it was supposed to go to in a reasonable amount of time. So the person in the previous complaint was an administrative person. I don't think they had anything to do with the trust money. That's why I recommend dismissal on that one. This person is the principal broker. So I recommended the same $500 for the same violation for trust money.
Fontaine did.
If you want me to go ahead and read 25, just the facts of it.
I would
can.
like it.
So, just so I'm clear, we just dismissed a complaint against somebody who's doing administrative work. Now, this complaint is against the principal broker of that administrative person?
Yes,
Of the
and
other
also the
person.
principal broker of the broker who was in the complaint from last time.
And
Which
it
did
involves
get a fine.
escrow.
Yeah, but not against, not for failure to supervise the administrative person.
Correct.
Okay, so make sure I'm clear.
Okay, I have a motion and a second on the floor to dismiss this. We need to vote on that motion. All those in favor?
Let me offer a substitute motion. We go ahead and get this read.
Okay,
Right? Let's
please do.
Read this into the record.
Thank you.
Number
Second.
25, into the record.
Read in into the
Okay.
record, please.
TREC opened a complaint against respondent for failure to supervise previous respondent in case 20150226641 above, and respondent owner in case number 20150217601, hereinafter owner. That was the one presented at the last meeting. Respondent had been actively involved in discussions and guidance related to services provided to complainant. Respondent maintains that proper notice was given to complainant regarding the owner's relocation to respondent's firm and transfer of complainant's management agreement. Respondent states that complainant was sent a letter on or about January 15th, 2014, and complainant executed an authorization agreement to receive direct deposits from respondent's firm on February 8th. Respondent sought legal counsel, who determined that the initial management agreement and January 15th notice was sufficient to deem the original management agreement as enforceable and that no additional management agreement was needed. Respondent believes that there was no duty to disclose that the affiliate broker worked as clerical assistants for both the HOA and respondent's firm. With regard to the delay in release of security deposit, respondent states that there was a clear recognizable difference in the tenant's signatures on the lease and security deposit release form. Respondent wanted to be sure that the escrow funds were distributed to the correct party. Respondent states that escrow funds are taken seriously and denies withholding escrow funds until management commissions were received. Respondent further states that the transfer of funds was handled very carefully and states that the internal bookkeeping process ensured that the funds were received and distributed in the proper amount. Respondent strongly refutes the allegation that the management agreement is unenforceable. Respondent further states that complainant is mistaken that terminating the management agreement means that complainant is not responsible for paying management fees. Respondent believes that complainant is still responsible for paying the firm 8% per month management fee for services rendered per the management agreement prior to complainant's request for termination. So the other part of this, which was the basis for the violation in the broker from last time, is that they're saying that they didn't release the money right away because the signature on the form they weren't sure that it was the tenant releasing the security deposit to the owner. However, there was an email from the tenant to the firm saying, please release my security deposit to the owner, and they didn't send that money until over a month later. So that's what that was based on.
A month is a long time.
And when they had supporting information that person wasn't going after.
Can I take my dismissal back?
Well, we already.
Motion to accept council's recommendation.
Oh, we have to vote on the other.
Yeah, the first one.
We have to vote on the first one first before.
Well, we did, John reconsidered the last
My substitute motion passed, which took the
Okay.
Which took the original motion off the floor. So we're
Okay.
back to a new motion now, which is to accept council's recommendation.
Okay.
So,
Are we ready to
Have we
vote?
made the motion?
I did.
Diane
Second.
made a motion
Say I second.
to accept council's recommendation, seconded by Ms. Taylor. Any discussion on the motion?
Does there need to be any education on this one?
It's up to y'all.
And if we really believe that the guy delayed sending money back when he should have, $500 might not be enough.
When he-
Somebody got a substitute motion or a friendly amendment?
I make a friendly amendment that he take, 8 hours of continuing education, but I don't know
Pull your microphone down, Fontaine.
8 hours of continuing education, but I don't know the class. Can you all help me with?
We've got a list here.
We need that 8-hour
There's a
core
property
class for
management-
principal brokers on things like this, I think.
Well, yeah, but we
But
don't
We don't have it
that.
yet, but
So in the
I'm just-
meantime, you all help me.
There's
with-
some property management classes.
I don't have that in front of me.
I would say property management class.
All right, then that's what I would say, that 8 hours of property management class within
180.
180 days.
Are you leaving
Added to
the,
this other, added to the,
are you leaving the $500?
yes, I am.
Okay, do I have a second?
Is
to-
that, that or a choice of a meeting or just the continuing education?
I think she just said C.
I've already said.
Are you giving them a choice of a meeting or property management
No,
or just property
property
management? Any further discussion on the motion? Okay, we'll vote on the amendment first, to add the continuing education. And if it passes, then we're good to go. All those in favor, please say aye.
Aye.
Opposed? Motion carries.
2016000201. Complainants viewed multiple properties and requested respondent to place an offer on a property on November 6. Complainants allege that respondent led complainants to believe that respondent only represented them for the property on which they placed an offer. Complainants later discovered they executed an exclusive buyer's representation agreement for a term of 1 year. Complainant states that they had concerns about the property line, and respondent stated a survey was not needed because the seller would mark the line. Complainant state this never happened. Complainant states that the property line dispute arose, and complainants forfeited their $1,000 earnest money to cancel the contract. After the termination of this transaction, complainants contacted another agent who previously sold one of the properties in order to view houses hereinafter the listing agent. And complainant states that the listing agent never showed them any property that respondent provided to complainants. Complainants said they had actually had a valid contract with the listing agent from a prior sale and were not aware of that it was still in effect when they signed with respondent. Complainants wrote a termination letter to respondent on December 1st, 2015, states respondent became angry and began harassing complainants and the listing agent. With reservation, complainants left a message with respondent to set up another showing since their representation was in limbo, and states that as of December 5th, respondent did not communicate to either confirm the appointment or to confirm the representation had been terminated. Complainants further state that respondent maintained that complainants owed respondent commission on the failed transaction. Complainants allege that respondent was unprofessional and vulgar and could not consistently get showing appointments. Complainants allege that this conduct constitutes misrepresentation. Respondent submitted a response stating that respondent had complainant call the listing agent and verified that complainants did not have a contract with the listing agent when they started working together. Respondent states that complainants wrote a cash offer on one property, then backed out. Respondent states that complainants fell in love with the property, and respondent spent time reviewing all forms they signed when they placed the offer the same day. Respondent states that they reviewed all inspection forms and even a copy of the plat, which complainants initialed. Respondent states that when the counteroffer came in, respondent met with the complainants at their home and reviewed all forms again. Respondent further states that complainants decided to cancel their home inspection and termite inspection, stating they were happy with what the seller provided. Respondent advised that complainants were giving up their right to a home inspection, and complainants would not receive the earnest money if complainants did not go through with the purchase. Respondent states complainants were good with that. Respondent states that complainants had trouble transferring their money from one of the banks and spoke to respondent about getting a small loan for the difference. Respondent states that respondent was working with the listing agent to extend the closing when complainants advised that there would be problems obtaining a loan. Respondent states complainant tried to get the earnest money back, saying there was a family emergency and funds were no longer available. Then later stated that there was a problem with the survey line. Respondent explained that because complainants had provided a proof of funds letter and forfeited their right to inspection, it is likely that complainants would not receive the earnest money back. However, respondent attempted to have the earnest money released to complainants, but seller denied the request and complainants forfeited the earnest money. Respondent states that they began looking at other houses and discussed proof of funds letters and a loan approval letter to move forward. Respondent states that complainants called on November 22nd advising of loan approval and requested that they contact seller's agent again to see if they would accept another offer. Respondent states that the seller countered but eventually accepted another offer. Respondent states that they started looking at more houses when complainants sent an email on December 1st giving notice that complainants were still under contract with their listing agent and stated they were grateful for the services respondent had provided. Respondent states that complainant asked respondent to find out if they were really under contract with the listing agent. Respondent states that all parties agreed they were not under contract with the listing agent. Respondent further states the complainants offered to pay the commission on the failed contract since it was their mistake that resulted in the failed transaction. Respondent states that respondent set up more showings until complainants advised that the listing agent would cut her commissions and advised them not to pay respondent commission on the property that was not sold. Respondent believes that the listing agent told complainants to have an agent show them properties they wanted to see, then the listing agent would write the offer and be able to work the transaction with lower commissions. Respondent further states that the listing agent advised complainants to file complaints with the state and the BBB in order to get out of the buyer's agreement and save on commissions. Respondent states that the email and text communications will refute complainant's claims and timeline. Respondent denies all allegations and states they are without merit. Office of Legal Counsel reviewed the documents provided by respondent, including text message conversations. It appears that there was some breakdown in communications around November 21st, but complainant sent a list of properties to respondent on November 6th and November 28th in which the respondent set up showings. Complainant sent an email dated December 1st stating that they no longer wished to use respondent services and that they had a valid contract with the listing agent. In that email, complainant thanked respondent for respondent services. Respondent responded, stating that complainant stated earlier they did not have a contract with the listing agent and did not want to use the listing agent. Complainant sent a text message on December 2nd to respondent stating that the listing agent will let them out of the contract since respondent is not acting professionally. Complainants also sent an email December 3rd stating there was no intent to play both ends against the middle, that the listing agent spoke out of turn when she told respondent she had been showing properties for 2 months and that they would like to set up an appointment to view another property with respondent. There was another email dated December 5th in which respondent states, as per our conversation, you informed me as to you are using listing agent as your realtor. I will cancel the showing I had set up. The exclusive buyer's representation agreement was between respondent's firm and complainants for a 3% commission. The agreement dates were November 23rd, 2015 through November 23rd, 2016, or at the closing of a property. It was executed electronically by complainants on November 23rd, 2015. There is a second buyer's representation agreement which is handwritten for a term of November 5th through November 6th. November 5th, 2015 to November 6th, 2016. Each page is initialed and there are handwritten signatures dated November 6th, 2015. The working with a real estate professional document was also signed on November 6th, along with a get a home inspection and property survey and additional offer documents. There is also a subdivision plat for the initial property which has complainant signatures. It appears respondent hired an attorney who responded to the BBB complaint on January 12th, 2016, refuting all allegations. Complainant sent an additional information in response, stating they have no confidence in respondent's ability to represent them in their best interest. Complainants state that during the document review, respondent handed them a representation agreement stating this contract is for this house so I can get paid, and did not realize the contract was for 1 year. Respondents state that in hindsight they should have read every word of the document, but they were operating under the assumption that the respondent had their best interest in mind. Complainants further reiterate that respondent advised they did not need a survey, that respondent still believes the commission is owed, and respondent was hostile. Complainants further allege they have not heard from respondent regarding their request for release from the contract, nor has respondent replied to the BBB complaint. Complainants also forwarded a message from the BBB dated February 22nd, 2016, stating the complaint will be noted as unresolved. The documentation provided shows that complainant and respondent had a valid buyer's representation agreement. The transaction documents do not show any indication of an issue regarding the property line, and the second offer put forth by complainants waives any inspection contingencies. It appears that even after the communication breakdown, respondent attempted to continue to show properties and did as complainants asked. It appears that respondent acknowledged that complainants wished to use the listing agent and no longer requested respondent services. The rest of complainants' allegations are based on he said, she said, and cannot be substantiated. Recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks and seconded by Commissioner Taylor to dismiss. Any discussion on the motion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
2016001071. Complainant, a licensee, and father are unit owners at a condominium complex. Respondent's firm manages the HOA. Complainant states that respondent has denied complainant access to association records and the management agreement between respondent's firm and a condominium HOA. Complainant alleges violations of TCA section 6627-101 regarding multiple ownership of property and unit owners associations, stating that all records should be made reasonably available for examination. Complainant states that respondent denies having a copy of the master deed.
Excuse me, Ms. Kirby.
Yes.
So is there anything unusual about this HOA complaint?
No. It is.
So it's not in our purview.
I do not believe that it is.
I'd make a motion, we dismiss this complaint.
Second. Motion made by Commissioner Grease and seconded by Commissioner Franks to dismiss. Any discussion on the motion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
2016001401. A complaint was opened against respondent for potential unlicensed activity. Respondent's company, Internet Advertisements, state that it specializes in getting people out of their timeshare and maintenance fees. The website states that it can eliminate any timeshare as long as it is current and up to date on all fees. The website further states that they handle estoppel requests to the home resort, power of attorney, getting the property transfer ready, closing of the property, including deed preparation and recording, title search, resort notification, and follow-up of the resort to verify transfer. A letter was sent to respondent advising of a complaint on or about March 10th, 2016, and it was marked delivered on USPS website on March 14th, 2016. No response has been received to date. The recommendation is a consent order in the amount of $1,000 for unlicensed activity in violation of TCA section 6630, that should say 32, 10223, which is timeshare resale broker must be a licensed resale broker.
Do I have a motion?
What's our maximum fine for this violation?
$1,000.
Okay.
Motion to accept council's recommendation.
Second.
Well, I would like to make an amendment that we have the class
That
added
one?
to this.
But they're unlicensed, aren't they?
Yeah, they're unlicensed.
Oh, there, I well, can't do anything.
Motion made by Commissioner Hills and seconded by Commissioner Wood to accept council's recommendation. Any other discussion on the motion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
20150225151. Complainant represented a buyer who was interested in a property that respondent listed. Complainant states that the MLS stated the property was a contingent show regarding the sale of buyer's current home. Complainant states that respondent indicated verbally that the seller and buyer had a 48-hour bump clause in their contract. Complainant's buyer submitted an offer on the property and the seller accepted with no mention that the offer was a backup offer or that there was a bump clause. Complainant states that the buyer's offer was accepted on October 14th, 2015 and became binding on October 15th. Complainant told respondent on the 15th that complainant's client had a home inspection scheduled for October 22nd. Respondent stated that respondent had not spoken with the other buyer's agent but would let complainant know if anything had changed. On October 21st, complainant reminded respondent of the October 22nd home inspection, and respondent stated that the original buyers were still trying to obtain financing and their complainant's client contract was a backup contract. Complainant asked about the 48-hour bump clause and indicated that this was between, and respondent indicated that this was between the seller and the buyer. Complainant reminded respondent that there was no indication on complainant's buyer's contract stating that it was a backup offer. Complainant alleges violation on the part of respondent for allowing sellers to accept two binding contracts. Respondent states that the property owner went under contract on October 2nd with a 48-hour bump clause, and it was immediately advertised on the MLS as contingent. Respondent states that complainant called the office during the week of October 12th and spoke with the agent on call, who was then contacted the principal broker. The agents negotiated a verbal backup offer the next few days, and complainant sent the new offer with agreeable backup terms as respondent understood them, and the agreement was bound by complainant on October 15th. Respondent states that complainant asked on the 15th, also, do you think there is any possibility the other contract will go ahead with their financing even if they haven't sold their house? Respondent's response was, I don't know that until I tell them we have a backup offer. Respondent worked over the weekend with the original buyer's agent to determine if the buyers were going to remove the contingency. Respondent was notified on October 19th that the original buyers were removing the contingency, and respondent immediately notified complainant verbally. Respondent states that complainant called to discuss the issue that the contract did not state it was a backup offer, and on October 21st, complainant's clients decided to pursue inspections and closing. Respondent states that this was a frustrating experience, that respondent did make a mistake by not ensuring that the special stipulations included the information this was a backup offer. Respondent states that it was verbally communicated so much and the MLS was listed as contingent that respondent believes there was no misunderstanding. Respondent states that the negotiations took place for nearly a week. Respondent states that complainant's buyer called the office and knew it was a backup offer, and respondent has a text to complainant stating it was a backup offer. Respondent worked diligently with the original buyers to get a response regarding removing the contingency as quick as possible. Complainant was informed the moment the respondent found out. Respondent feels the respondent acted swiftly in every response and worked hard for respondent sellers while maintaining respondent's duty to be honest and ethical with all parties involved. Respondent believes that complainant had the same responsibility and believes that complainant left off the backup contingency even after discussions. Respondent states that complainant's texts on October 21st imply that complainant did not know it was a backup offer until that moment, although complainant and broker called the office that day before to address the concern. Respondent further states that complainant's buyers never provided a pre-approval letter or a copy of the earnest check. Respondent states that an honest mistake was made by not ensuring the backup offer was included in the special stipulations. Respondent states that all parties understood the situation and it is all of their responsibilities to act honestly and ethically, stating that it was negotiated and treated as a backup offer the entire transaction. Office of Legal Counsel requested and reviewed the transaction documents and communications between agents. Text and email communications between the agents indicate that complainant knew complainant's clients were in backup position. However, the contingency or the fact that the offer was a backup is not included in the backup contract. Recommendation is a consent order with a civil penalty in the amount of $500 for violation of 1260-02-.07. Brokers and affiliate brokers shall make certain that all terms of the conditions of the real estate transaction are included in the contract of purchase.
Do I have a motion?
Excuse me, .08. I miscited the reference there.
Well, I'll make a motion
Okay.
that we up the 500 to 1,000, because I think that's a big item that
Okay.
they left out. I mean, she basically sold the house twice. And then I would add on that we have education, and again, you all are gonna have to help me with the class that would be sufficient for this one. Because I don't know what I've done with my class, list of classes.
Well, there's contract writing classes.
And this is a broker also,
That's a broker.
but not a principal broker.
I'd say contracts.
All right, so you take a contract class, 8 hours of contract, within 180 days.
Are you giving them the option either or just a contract class?
Which will they benefit most from?
They're gonna have, from the contract class?
Right.
You need a
Do I have
second?
a
You got it.
Second.
Second.
Okay, motion made by Commissioner Taylor that we offer a $1,000 civil penalty and 8 hours of contract class, and seconded by Commissioner Hills. Further discussion?
Can we make sure I understand? So there's one agent that filed the claim, is that right? The one agent
Yes.
went against the other agent?
Mhm.
Okay. But don't both agents have responsibility? I mean, because the one agent knew that they had talked about it being a backup,
Mhm.
but didn't reduce it to writing. And then she's turned around and filing a claim against the other one. To me, they're both wrong.
Right, yeah, I mean, it did appear that they both knew it was a backup contract. You guys would know better than me about who's responsible for putting it in the contract, so.
I think they're both responsible. So if we were to pass this, can we turn around and then ask you to check into the other agent? I guess the one that filed the complaint. Would that be wrong?
We can do that. They probably won't be very happy about that, but.
Bam.
If we were doing what it did to make them happy, we wouldn't have done anything today.
No, I know, I got you. Yeah, we can certainly do that. If
Okay.
that's what the commission.
Okay, so we want to
Would like.
vote, ready for the vote on the motion. All those in favor, please say aye.
Aye.
Opposed? Motion passes. Commissioner Wood?
And then I would like to ask legal counsel to look in and file a complaint against the claimant here, because they had just as much responsibility.
Do I have a second?
Second.
Discussion on the motion.
Would we file a complaint, or just we already know the facts, don't we? That
Well,
they-
we have to file a complaint.
Okay, gotcha.
Yeah, they have
And
to
they
have
have
an
to receive
opportunity
it.
to respond.
So I have a Motion filed by Commissioner Wood and seconded by Commissioner Grease that we open a complaint against the complainant in this case. Any further discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
2015-022-5171. TREC opened a complaint against respondent for failure to supervise previous respondent in case number 2015-022-5151 above, hereinafter broker. Respondent first became aware of the second offer after it was bound and immediately called broker to explain that the seller accepted the second offer without mention of it being a backup offer. Respondent states that broker verbally discussed the contingency with complainant and that it was published in the MLS. Respondent explained that it needed to be in the contract and broker should immediately inform the seller. Respondent states at that time the first offer released a contingency and were moving to close the transaction. Respondent spoke with complainant's principal broker and agreed it should have been in the contract. However, complainant's broker acknowledged that complainant and buyer were both aware of the first offer and the 48-hour bump clause. Recommendation, consent order with civil penalty in the amount of $500 for TCA section 6213 312B 14 and 15 with failure to supervise.
Do I have a motion?
I make the motion that we do the same thing to the broker, that we do the same thing for the broker as we did for the agent. The same penalty of $1,000 in the same class.
8 hours of
8 hours of
contract.
continuing education in the
Do I have a
contract.
second?
Second.
All right, so if we've, a little conversation about this, if we've opened one against the other one, we'll have to do that with their principal broker also, okay?
But, and when it's presented, it will be,
Talking to you, Mike.
and when it's presented, Mallory,
Yep.
it would be referencing the cases we've heard, correct?
Yeah.
Any further discussion on the motion?
What was the civil penalty was?
Civil
1,000.
penalties, 1,000 with 8 hours of continuing education and contract writing.
Okay, 1,000 for the one violation? Okay.
All those in favor, please say aye.
Aye.
Opposed? Motion carries. Number 31.
2016-000-671. Complainants filed a complaint against respondent, who was the property management company for the property which they leased. The property is located in a neighboring state. Complainants state that the final walkthrough on or about May 15th indicated that the estimated list of move-out damages was 0, but complainants received a letter dated June 30th indicating a reduction of security deposit in the amount of $200. Complainants state that they contacted respondent on numerous occasions and were finally told that the $200 was an erroneous charge and would be refunded. Complainants state that the initial and full refund was not refunded within 30 days. The notice of final reconciliation was not provided within 30 days. A full refund has not been provided as of November 4th, and improper care and customer service was not provided to resolve the issue. A response was provided by and through counsel stating that the rental property is in another state and the licensees managing the property are licensed in the other state but no longer affiliated with the company. Respondent states that respondent assisted with bookkeeping and not with the management of the property. Respondent states that once respondent became aware of the disputed $200, a check was forwarded to complainant at complainant's place of employment on September 15th, but was lost in the mail. That check was canceled and another check was issued on September 28th and mailed October 5th to the same address. Respondent believes the complainant received the $200 in dispute. Respondent denies any wrongdoing. Office of Legal Counsel requested the property management agreement, lease agreement, and copies of the checks referenced by the respondent. The property management agreement is between respondent, manager, and LLC owner. The management agreement tasks respondent with all of the normal property management responsibilities, not just bookkeeping, including inspecting the property and producing a written report of the inspection after the tenants move out. The copy provided was not signed by either party, but the signature line has respondent's principal broker listed. The security deposit breakdown letter sent to tenant is from respondent. It was sent to complainants on June 30th, 2015. The lease ended on April 30th, and complainants state they moved out May 15th. The second attempt at a refund check was dated September 28, 2015. Respondent provided an email from complainants requesting their money on September 15th, but it appears that this has been an ongoing discussion since complainants moved out of the property. The recommendation is consent order for $500 for violation of Rule 1260-02-.09. Trust money must be dispersed in a proper manner without reasonable delay.
Do I have a motion?
I would move to accept council's recommendation with the $500 violation, but add 8 hours of continuing ed in property management.
This is a firm.
Oh,
not a person.
then take the last part out.
Do I have a second?
Second.
And I have a question. So it's an out-of-state property management company.
No, they're licensed in Tennessee. The property itself was in a different state, so they may also be licensed in that other state. I don't know, but that would be the other state's
Issue.
issue if that's the case.
Any other discussion on the motion?
I second it.
All those in favor, please say aye.
Aye.
Opposed? Motion carries.
20150225071.
Motion
Complainant,
to dismiss.
Do I have a second?
Second.
Commissioner Hills made the motion to dismiss, seconded by Commissioner Franks. Is there any discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries. And
Tues-
that was because that is a timeshare issue, and timeshares typically have all their i's dotted and t's crossed, and we really can't do a whole lot about their paperwork because it's always in good shape.
2016001281. Complaint was filed against respondent, timeshare salesperson regarding the same
Motion to
circumstances.
dismiss.
Second.
Motion by Commissioner Hill, seconded by Commissioner Franks to dismiss for the same reason. Any discussion? All those in favor, please say aye.
Aye.
Opposed? Motion carries.
Okay. So I have an addendum to legal report. This is kind of an unusual thing. We have received a request for a hearing from a licensee pursuant to TCA section 6213.312F. This licensee is an affiliate broker. So that's the statute that says if you've been convicted of certain types of offenses, you are automatically revoked, your license is automatically revoked unless you request a hearing within 60 days of the conviction. So this person has been convicted and has requested a hearing. That conviction, this person pled guilty in federal court to one count of conspiracy to commit bank fraud. According to the facts set forth in the guilty plea, respondent and the co-defendants in the case caused a short sale of residential property to take place from co-defendant husband to co-defendant wife using the wife's maiden name in order to represent to the bank that it was an arm's length transaction. So the commission has a couple of options in how to address this hearing request. The first one is that we can open a complaint as like a normal complaint. This would allow the person, the licensee, to respond to the complaint. I assume that they would say why they think that the commission should not be revoking their license. Then the commission could then, if the commission chose to authorize something less than revocation, then that would be, a possible reason why to maybe do it this way. But then if the commission thought that it should still be revoked, it would proceed like normal. They could either agree in a consent order to revoke the license, and then we wouldn't have to have a hearing. Or if they didn't want to accept that, then it would go to a hearing anyway. The second and third choice kind of go together. Under the Administrative Procedures Act, the commission can do what's called a summary suspension. This commission may have done one before, but there hasn't been one since I've been here. Which there's two ways that it can be done. So essentially, summary suspension is suspending the person's license before the actual hearing can take place because it's deemed to be imminent harm to the public. And there's two ways that can be done. The commission could vote today to suspend this person's license. However, in doing so, the commission would have to give this person a hearing within 7 days. And that could be done telephonically, but it would have to be done in 7 days. The other choice is to have a hearing. Well, yeah. So the other choice would be to have a hearing at the next meeting to suspend the license. Then another hearing would be scheduled later on down the road for the actual, whether it's going to be revoked or not. So those are kind of the three choices. It's either open a complaint, go about it that way, or summary suspension either today with a hearing on the suspension in 7 days, and then another hearing later on the revocation, or have a hearing at the next meeting on the suspension, and then another hearing later on about the revocation.
When did he plead guilty or she plead guilty?
The guilty plea was signed in February, but it was not entered by the judge until March.
Did the licensee submit the information to us?
Yes.
Reported it
Mhm.
correctly? Okay.
Requesting this hearing, yeah.
So what is your recommendation?
I really don't have a preference. I think any of them are fine, whatever this commission wants to do.
But this person has pled guilty in federal court of conspiracy to commit bank fraud. We don't typically give licenses to people who have had a theft of money. Is bank fraud included in theft of money?
Yes, and it's also a felony.
Felony.
But
Okay,
but by statute, we can't just revoke their license now, like, because they've requested this hearing. If they've requested the hearing within the 60 days, they have a right to a hearing. So
So are they doing real estate right now, this moment?
I do not know.
But they
I mean,
could
they have a
be?
license, so they could be.
So I think we need to do something expeditiously.
So would you like to make a motion?
I'm trying to think about the 7-day thing, though.
If you're available in the next 7 days?
Yeah, I will be in Washington DC.
The other choice, if you want to do the summary suspension, would be to have the suspension hearing at next month's meeting in June. So that means they would have an active license for a few weeks. I mean, that's what, 3 weeks away? That may be the best solution, unless you want to have a telephone suspension hearing in 7 days.
That'd be hard to do on a phone.
Next month. is
Next
gonna be
month.
better. Next month is gonna be better.
I'm
For
sorry,
everybody.
Fontaine, will you
I
pull
think-
your microphone
I
down?
think next month is gonna be better because it gives everybody time to get their, like his pleadings and everything.
4 weeks.
All ducks in a row. And next week, half of the people are gonna be at NAR.
And
so-
he had no prior, he or
Right.
she had no
Mhm.
prior disciplinary
Mhm.
actions.
So would one of you ladies like to make a motion?
Well, the motion is that we have a hearing, I make the motion that we have a hearing, for this person next month, at our next month's meeting.
So just to be clear, that hearing would be just to suspend the person
Mhm.
until another hearing could be scheduled for the actual discipline on the license.
Mhm.
Yeah.
Do I have a second?
Second.
Okay, any further discussion on that motion?
Yeah, I got a question.
Okay.
Instead of doing the 2 hearings, why come you just can't open an investigation on them? I
Well,
think that's the first thing that you gave
there's-
me that, right?
well, this is a little bit different than our complaints because this is pursuant to a specific statute that says if you're convicted of any of these types of crimes, your license is automatically revoked unless you request a hearing. So that's why it's a little bit different because this specific thing is addressed in the statute.
So they'll have the opportunity to respond at the next meeting.
At the next meeting for the summary suspension hearing, yeah. I would imagine that this person would be there with
Well, that was
possibly
gonna
their
be my
attorney if
next
they have one.
question. You know, if we schedule it, do they have an option? Or if they don't come, then we would suspend it and
Yeah.
go? Okay.
Any further discussion?
Let me just say for the record, I've got much knowledge about this case, and so I'll be recusing myself on any vote throughout.
Okay. So noted. Any other discussion? All those in favor of Fontaine's motion to have a hearing at the next commission meeting on June 1st, please say aye.
Aye.
Opposed? Motion,
One recusal.
one recusal. Motion passes 7 with one recusal.
Yeah, we'll just also want to make sure, because we have 2 commissioners out and 1 recusing, to make sure everybody else is here so we have a quorum.
Can we do this one on the 1st?
Yeah, I think so. I don't see why not.
Well, I mean, this one will be a short,
Yeah, I mean, I don't think we need a judge for this type of hearing, so I would think we should be able to do it on the 1st.
kind of like an informal appearance, right?
Yeah.
So when is Oklahoma City?
We'll leave the night of the 1st.
Oh, okay. I didn't know if y'all were coming at all or just
Yeah,
you were coming the first
We
day.
could be here for it.
Okay.
We'll be here on the 1st. We'll leave that night. I think. Isn't that right, Malcolm?
That is correct. I got your error information.
Okay, thank you, Janet. We've got one more piece of information to handle here. Mr. Young, regarding errors and omissions insurance, you've done a little research.
So have basically, from our current provider, they currently offer increased limits of $250,000 per claim with $750,000 aggregate, or $500,000 per claim with the $1 million aggregate. And to her knowledge, some of our other providers also provide those same aggregates. So I think you could probably, in my estimation, go with the same proposal that you've had in the past, because you currently have those options that you listed out in your discussions.
Ms. Taylor, what do you think about that?
I think that's fine if people really know about it, and that's where my problem comes, is that I don't think a lot of agents realize they have the options and what the options are.
They do send it out to them.
And perhaps our next newsletter, since this is a renewal year.
That might be a good topic.
I think it would be, because I will say that, you know, when you get an insurance, any kind of insurance, my propensity is to, okay, bottom line is I owe $100.
Yeah.
Send the check.
Mine too.
And I don't really look at it, which is telling you something about me, so don't send me a bill.
All right, so are we cool just letting the RFP go forward?
Yes.
Okay.
Okay, with no additional changes.
Right.
Okay.
All right, so we're basically concluded with our business here, with one exception. We'd like for each commissioner who has a comment to make to the audience, to the staff, to the people of Jackson, or to Janet DeCharo. And then we might have one other piece of business before we handle that.
I have one question.
Okay.
What is funeral and burial?
I think some from other commissions got left on the iPad.
Okay,
so
thanks.
don't worry about that.
Our last item was funeral and burial.
All right.
Your funeral, your burial.
Commissioner Wood, anything you'd like to say?
No, I'd like to say, again, we already talked about the Central West Tennessee Association of Realtors. Been awful nice to us here the last day or so, and I appreciate that and the relationship that we have. And I like Jackson a little bit. I have a daughter here at Union, and I'm sorry, I'm going to tell a story. Years ago, we were traveling through Jackson, and we stopped at IHOP, okay? And so we were there and asked a young lady waiting on us, what do you want to do in your life? She goes, well, I just got out of high school, but someday I want to go to Union.
Go to where?
Union.
Oh.
Union. Apparently, that's how people talk at IHOP. So, she wanted to go to Union, and we said, "What's Union?" And she said, "Well, it's Union University." And so we got in the car and we were laughing and about that'd be funny to go to a place called Union and stuff like that. And then a few years later, my daughter decided she wanted to go to Union, so she's been here, and so we're tickled. She'll be graduating here in a couple of weeks. But thank y'all very much. Y'all been awful nice to us.
Commissioner Horn, excuse me.
Haynes.
Yes, I would just like to say.
Put that microphone up there, because you have words of wisdom almost always.
Oh, yeah. I appreciate the hospitality that we have received here in Jackson, and ask all the commissioners and those who have to drive a long way to drive carefully. And I ask you to always remember that you can't purify the water by painting the pump.
By doing what?
Paint the bucket.
Okay, thank you.
Think about that. We'll mull on that.
All right, Ms. Taylor, West Tennessee representative. West Tennessee representative.
I'm West Tennessee. Thank you all so much. Jackson has always been one of my favorite places to come for a lot of reasons. The hospitality being high on the list. And thank you again for having us. And I hope you learned something. I certainly always do.
I'm sorry, I'm a little remiss. Bobby Wood, whose daughter goes to Union, is from Mount Juliet, east of Nashville. Johnny is from Chattanooga, and Fontaine is from Memphis. Now, Ms. Franks, who's from Franklin, You have the floor.
I too want to thank the Central West Tennessee Association. Y'all have been so nice to us. It's great that so many of you have come and sat here today through this. We really do appreciate you. And I know there's some people here that had to come, and I hope you did learn something from this. I learned something every meeting. I'm a principal broker, and I learn something every meeting. I get a little more scared every month. So I just, my daddy used to have a sign over his head in his construction office, sign back behind us, and it said, always do what's right. It'll please some and amaze the rest. So just always go by that, and just always do what's right, and don't be on the fence about anything. This is an important business, and we need to be professional at it.
Thank you, Marcia.
Thank you.
From Kingsport, Tennessee, Commissioner Hills, Diane Hills.
Again, thank you. We've had a hospitality, and thank you for inviting our spouses also. That was very nice. This is my first time in Jackson. It's it's really a nice place. It really is.
It is cute.
Yeah, it's just really, I was surprised.
Did you not think it was
No,
gonna
I
be?
didn't. I had no idea. I just passed it on the interstate before. But if you're a broker, I do want to remind you, June 1st is your privilege tax. And you may not receive the bill, but it is responsible to go online and pay your broker privilege tax by June 1st.
Diane also works with finance and administration. You're in charge of revenue for the state.
No, I don't want anybody to get
I got it.
In trouble.
Yeah, I miss it, because if you don't get the bill.
I'm going to give Janet the last word. I do want to remind you all that you need to sign out on the way out, okay? And we have excellent assistance with staff here, and so if you have an issue within a few days of your license being posted as active again, you know who to talk to. But I suspect it'll be handled expeditiously and correctly, so I don't think that'll be an issue. Janet, thank you for hosting us. We've had a great time. Look forward to your remarks.
Thank you all for coming here. We invite you back every year. We're more than happy to have you in Jackson. Thank all of you for coming, and be safe out there.
Don't forget to sign out.
We have on the road with pork treats and dog on the road retreats where you okay.
Well, I'm not
Get me back to the hotel. Fish in the water.
All right, we just gotta pick up.
Brooke said, do what?
Y'all may want to, we have to clean up. Y'all can drop Johnny a second.
Yeah, you
What about Greece?
Pardon me?
He's leaving right now.
Bobby, have you got, when can you drop Johnny at hotel?
Yes, I can. Yeah, I don't mind.
I will. I'll get it going.
I think he
Brooke
was
said
gone.
there was gift bags and
Sometimes you get some amazing,
John was trying to get ahead of Diane.
Hope to work with you some more.
Yes, sir.
Well,
Is John leaving?
Have fun next week.
Yeah.
He's got his car?
No,
Yes, you will be.
Oh, she's picking it up.
Yeah. Oh, yeah.
Thank you very much. Enjoyed it so much last night. Thank you. Thank you.
try to behave.
Hey, bud. How you be doing? Good.
Yes,
So
sir.
you work with.
Yes, you will. Yes, you will. Thank you. Thank you. Enjoyed being here.
Glad you're here. Yeah, I remember you. It was great seeing you. Yeah.
I got my actually,
Yeah, we could probably
Well,
stick to that.
Cindy's phone started talking, it started giving her directions to Woodstock Bakery. Because she was going, she said her started talking to her.
We'll see what we can do to make the right time.
Pastor church in here.
Thank you. It's great to see you again.
That's my house, brother. Hey, you enjoy it, brother. enjoyed it.
You be careful going home, okay?
Okay, thank you now.
Glad you're having one to graduate. You're gonna feel like you have a raise.
That's one big check. Don't get to go out in the year. And of course, the back.
Well, it's a,
Merit change license.
yeah. Back to the ranch tomorrow.
I'm gonna get my goodie bag. I'm gonna get my goodie bag. All right. I want a goodie bag.
I want your goodie bag.